May I be permitted to mention matters? One WPC 17524. Lordship, remember that charitable society, Lordship fixed it today.
So the page was mentioned.
Oh, no, he's not there in the board.
For page mentioning, supplemental list, fresh admission, page number 1, item number 125.
My lord, item number 1, on behalf of Mr. Kuris Prasad Das, kindly take a look one thing, my lord. Because the file is Mr. My lord.
What is your good name?
My name is Pramodhan Satpata.
Pramodhan Satpata.
Satpata, SJPVD.
Okay. Research. On instruction of Mr. KP Das and consulting to the appellant, let the matter be listed on 13th of September 2023.
Yes. Page number 2, item number 6 to 12. Page number 3, item number 13 to 17. Page number 4, item 18 to 22.
My lord, item 18, my lord. My lord, Senior Pitambar is leading me in this matter. He's in accommodation today. So may I pray for a accommodation?
Have you informed Mr. Mishra, Siddharth Mishra?
Your lordship, we had taken the consent of the state.
He has informed me that he is going to, because he is in Delhi. Today morning he has called me.
With the request of Mr. S.S. Tripathi, like for the
but these are all related to
14th of August. Other matters you have fixed, Mr. Acharya's matter yesterday.
That's 16th.
16th of August. Okay.
Deeply organized.
This is more or less equal to that particular case which your lordship has fixed to 22nd of September.
Already you point out on the day 16th, we'll just merge all the cases.
Page 5, item 23 to 25.
Item 25.
Yes.
Item 25. And this is regarding filling up a post of more than 150 of assistant station officers.
Yes.
Listen, there is an interim order. We are not in a position to fill up all these posts.
Who is appearing for the respondents here? Sorry, the petitioners.
Although I am appearing for the petitioner and Mr. Mohantila's senior counsel is appearing in behalf of the petitioner.
We'll take up the matter today.
Today after all, because in the past half, Mr. Mohanty has some personal difficulty. After all,
That's all right. We'll call out the matters. If difficult, you point out, we'll accommodate accordingly. But if this matters will be taken up today, Mr. Mohanty. Yes.
Page 7, item 26. Page 8, item 27 to 30.
Wait, please, last. Item 28, my lord. The read appeal double of 2022, my lord. It is infructuous, my lord. In the meantime, Bar Council Institute.
Item
28, my lord.
28.
Infructuous, my lord.
both the written
Both the items.
Both, my lord.
file a memo.
My lord.
You are mentioning on behalf of
Amit Prasad Bosman.
You good?
Das, Austrian Bar Council. Amit Prasad Bose.
Your name?
My name is Joint Kumar Party, JK Party.
Mr. Vincent appearing on behalf of Mr. Amit Prasad Bose and Council appearing for the appellant.
The second appeal.
Stated
I'm for the State Bar Council.
state petition. This writ appeal has become infructuous.
You for the Bar Council. Yes, give a memo.
File is subject. We do not find any impediment to grant leave to do this. We don't find any to dismiss this appeal. We do not find any impediment. So just go out this way. In view of the above statement, this readable stands dismissed as infractious. What is your good name?
Basmati Pradhan.
The same way. Next also.
On behalf of Mr. Amitabh Das. Memo, you bring signed by Mr. Das.
Page 9, item 31 to 36. Page 10, item 37, 38 and 39. Page 20, item 40. Page 21, item 41 to 46. Page 22, item 47 to 51.
Lord, item 49
Lord, pursuant to the state's reply to the rejoinder, certain documents have been brought on record. I have instruction to file a short affidavit to that effect, my lord. Only a week's time I'm seeking.
My lord, this question also, my lord, put to my learned friend in the last date of hearing, whether you intend to file any reply. He categorically stated, no, I don't want, petitioner don't want to file any reply.
Lord,
Now this is fixed today for hearing.
my lord, only the view of the fact that the rejoinder was served on me during the court, my lord, I was unable to take instruction. Pursuant to the sending of the affidavit of instruction to file a short affidavit, my lord, only confining to those 2 paragraphs.
Yeah, this matter will come on 16th of August.
My
Yeah, I don't know what.
49.
Maharana, waiting for the, you are for the state.
Yes.
Page 23, item 52 to 57.
May I please, Lordship?
My lord, item 53, my lord. We received the counter from the state, my lord. Would I humbly pray before your lordship if
I'm just mentioning item 53. My lord, this matter relates to Baravati Palace. Your lordship has given me short time to file affidavit, and an interim order was passed restricting us to proceed with the work. And I have filed affidavit since last 3-4 days, and today the matter is listed. So my only some prayer is that it should be upgraded for hearing at 12 noon. And he is saying that he wants to file rejoinder.
Let us first
But-
say that.
My lord,
Let us first examine, because it's a public interest litigation, we may not allow you also to file the rejoinder if you are satisfied with the documents.
my lord, a couple of documents have been annexed to the
We'll see.
counter affidavit.
We'll see.
We'll see the documents, bring the documents before us, we'll see what kind of documents, then definitely if accommodation is required, we'll accommodate, but we want to see the documents.
My lord,
Otherwise, it declared this interim order.
Outer term आगे दे दे.
Well, that is true, but thing is that I am the petitioner of that year. Yes. So.
he is the petitioner.
They have handed over the counter affidavit tomorrow itself.
No, tomorrow.
Yesterday.
Yesterday, no. You see the, I'm showing the receipt, not
So I
yesterday.
will file our rejoinder. Kindly.
No, Mr. Patnaik, I think one thing you decide amongst yourself, your counsel and yourself,
Yes.
who will address the court. We will not allow 2 voices for the same party. You decide yourself. We have no choice. It is your choice. You are the petitioner. In my long career, I have never seen this. This should not happen.
Only the band.
No, so from today on, you are going to make submissions for the petitioner? Then you disengage your counsel?
No, come, my.
Then he already made a submission. We have said when we take up, when it reaches.
We will look into the documents, what kind of document, then only we will question. Otherwise, we'll vacate the order, we'll give you a time.
It will be taken up at 12.
All at 12, 12:30, whatever.
12 or 12. Obliged.
May I please, Lordship? Lordship, item number 54. Lordship, my humble submission is, can it be taken up, Lordship?
It is there on list, you wait.
WBCRL.
Yes, Lord.
You have to be there. Last time you had missed.
No, Lordship, last time I was present.
Page 24, item 58, 59 and 60.
Oh, bless.
But item number 60, there is a specific order of my lord. The matter is still taken up at 2 p.m. This is a matter taken promotion from Orissa District Service to Indian District Service. Last order, it was categorically the order is that it's to taken up at 2 p.m.
In this case,
Item 69.
item 60, in this case, I will file counter in course of the day. I would have counted.
State has already filed counter and I have filed rejoinder.
I would have on just like item 60.
60.
60.
Yeah, 60.
All right, Mr. Muduri will say it, huh? All right, it will be taken up. Mr. Muduli, though it is not in the cause list mentioned as at 2 p.m., but in the order it is there at 2 p.m. Take up the matter at 2 p.m.
May I, with your lordship's kind permission, beg to mention, my lords. WBC 17524. A few days back, I mentioned this
I
matter,
remember.
and
It is, it will be taken up tomorrow. Tomorrow. You also, who is appearing for the state in the matter?
no, it's a Union of India, my lords, because
Oh, yes, it is a.
yeah, and they have stopped the foreign
I
contribution.
understand. I remember the case. You just inform Mr. P.K. Paril and it.
My I'll mention.
Yes.
Why don't you mention, my lord, matter for restoration, my lord. Read application dismiss for default.
File an application, what is the mention?
I have filed an application and,
Come automatically.
my lord,
What is their urgency in the matter?
urgency because, my lord, during pendency of my restoration petition, one of the respondents
When
showed
the matter was dismissed,
18th and, my lord, 22,
22, and when you filed the application?
my lord, 16/11.
Already, it has been not been lifted.
No, my lord.
And you have not mentioned during all these months.
My lord,
Suddenly become so important. Already give the mention. No? We'll
my lord, so that because
take up. 16th of August. Huh? It will come on 16th of August.
16th of August.
August this month.
Pardon, my lord, this is filing for memo for withdrawal, my lord.
The new matter. Tomorrow it will come.
Pardon the mention, on criminal appeal, wherein Justice Ratho is concerned, your lordship is directed 2 months before.
Mr. Zakrullah, who?
Your lordship,
I?
yes.
Okay.
So that is your lordship has directed to list this matter in another bench, available bench immediately. File is sent from this section, but listing authority is not listing. Last 2 months are following.
Whether Justice Ratho can hear the matter.
No, that is why it was
All right.
directed by your lordship to list before.
That you don't file the memo, you go to the registered judicial.
They I have given several.
Mr. Jafarullah, let me complete it. Say that this matter should be administrative side should be placed before me. Okay, just inform the registered judicial. You will come to me with your mention memo.
My lord.
With the lord. I may pardon, my lord.
Mr. Zakrullah, next time you mention,
What?
mention my name and
One matter is read up.
like this and make these gestures. All right?
My lord.
One specifically, your lordship has special statute matter discharge petition. Your lordship had heard it twice. And it was directed to be listed on 21/3. The matter has not come on. I had waited
21/3.
2020 specifically. I attached the order of your lordship.
Just ask the superintendent of the listing sections to meet me in the listings, okay?
With the order it is there.
All right, I will just asking the superintendent of the listing section to meet me. I will just check out what is up there.
And the matter may be immediately listed.
That will be done. That is the purpose.
My lord.
With the lordship's kind permission, my lord. My lord, on 18th of July, your lordship had directed this matter to be listed on 10th of August. Somehow it has not come on the list. My lord.
Tomorrow, just take up. It will come up tomorrow.
My lord.
You inform the council of the other side.
I have already informed and Mr. Durgan and senior counsel appearing in the other side.
Yes.
I have taken consent and he said that tomorrow he may be in difficulty. But what we request, if
If
it is
not
possible-
tomorrow, it will go to the 16th of August.
No, 16th also he is not there. I just talked to him. He says we are also interested if this matter can be referred to mediation because we are traders.
No, that we will not, because let the matter first be listed. We will see whether it is a matter to be referred to mediation or not. That will be decided on merit of the case.
Then tomorrow, my lord.
Yes. Tomorrow.
I may pardon, my lord. This matter is read appeal. Content is fixed to tomorrow. May I pray this matter be taken up tomorrow?
It is about to.
And another has read in next week any day.
We'll give a date on 16th or 17th. 16th or 17th, between 2 days.
No, one matter tomorrow and
That has been.
any day next week.
Pardon to mention, my lord. Lord, I'm extremely sorry I could not reach you in time. Item 25. Lord, on the last occasion, I had undertaken to file an additional affidavit. I have made the additional affidavit ready, but the annexes which had to be attached with the additional affidavit are not legible. I have asked the petitioners to bring the
25 that promotion to the post of assistant station.
No, this matter will be taken up.
27, my lord. 27.
Mention 25, that is right.
It is
Mistakenly, my lord. Item 27. It is relating to Sand Saurath lease. The villagers.
Yes, I am appearing for the.
Yes. What happened?
That can be deferred to it because he wants to file rejoinder. It's no urgency.
All right. Let the matter be listed on
Agenda has been filed.
Yes.
Rejoinder has been filed.
additional affidavit.
Additional affidavit.
Let the matter be listed on 14th of September 2023. While the petition is permitted to file an additional affidavit only for purpose of bringing on the new documents on record. No new amendments in the affidavit. Because if you have filed a rejoinder by your additional affidavit, you cannot expand the scope of the rejoinder.
But there are some subsequent development. I have
That you can brought already. Initial and subsequent development, if any, that has taken place up to filing of the rejoinder. Already.
No, Karam, item number 12 pilot, to stand.
Today you just wait for its regular call. Yes. Oh. Is it there? Term board? No.
The appealant challenge order dated 29/11/21 of the Honorable Sinking Ways was directed to give appointment to the LPG distributor. The fact of the case is, no submitting this case matters, I am appealing to respondent. Pendings of the recoupling members, they have allowed me and allotted me this and allowed me to permit that construction area ministry permission, building permission, approved it. And also we have started construction because of this rainy season and all these things. There is a delay of construction. That is what I requested. I will bring all those matters. I will be permitted 3-4 days time so that I will bring all those back to the notice of Honorable Court.
Already, we just, you accept notice, we are, pre-admission notice we are issuing.
Yes.
You are Mr. Patnaik.
Yes.
Or Mr. Shamalandu Patnaik. And counsel came to the appellant by means of this intercourt appeal. Order dated 29/11/2021 delivered in WPC number 23072 of 2015 is challenged. Issue pre-admission notice returnable on 22nd of August 2023. Since Mr. Dayananda Mahapatra and counsel appears for the sole respondent, no formal notice is called for. On the next date, there shall be an attempt to hear the matter on merit. Stop. We were on merit come prepared.
Any contempt had been filed?
Contempt has filed. They have submitted that contempt of filed, but we have not received any notice. Contempt has filed. There was a direction to comply it within a stipulated time. We have submitted that copy. Thereafter, my lords, kindly have a class to this.
No, we will not see come on that day.
No, so I will bring out all this.
Let's proceed, yes.
Item number 3. Here the petitioner challenges the order and annexure 5 passed by the Honorable Single Judge, rejecting my dismissing my writ petition. Your Lordship may kindly turn to page 36 of the order of the Honorable Single Judge that the writ petition is not since alternative remedy under section 9 of the OCH and PFL Act is available, which is completely incorrect, my lord. The fact of the case is like this, my lord. My lord, your Lordship may kindly turn to page 26, annexure 3.
What is this OCH and PFL?
Orissa Consolidation of Holdings and Prevention of Fragmentation of Land Act.
Okay, the Consolidation Act.
Yes. My lord, the land admittedly belongs to the petitioner, and it was so recorded in the draft record of right in the consolidation proceeding. The present opposite part number 1.
Yes.
Find the revision under section 37(1) of the Consolidation Act. Do not make us a party. To make state representative of the Tahsildar a party. We are not hard. Then the order is passed by the commissioner directing the consolidation officer to carry out the order to record the land in favor of the opposite number 1. Accordingly, that is annexure 3, my lord.
Okay.
Accordingly, by annexure 4, this consolidation officer carried out that order. So, no objection was filed under section 9.
All right. You are Mr. Bag?
Yes.
And Mr. B. Bagler, counsel to the appellant. By means of this intercourt appeal, the order dated 16/9/2022, passed by the Single Judge in WPC number 2798 of 2017 has been challenged. 2007 has been challenged. So, to be heard on merit. issue notice is made returnable on 26th of September 2023.
Notice to only respond number one, my lord, he is a private party.
The appellant shall take steps for service of notice on the respondent number one. We are not issuing any notice on the other respondents as they have passed they'll be part of the process from which the impugned order has been issued and their statutory authorities. So such steps for service of notice will be taken within 3 working days. Okay.
Mr. Bag, there's a small defect.
I don't know that.
Authentication fee.
My lord. Item number 4. Please, lordship. But if the appellant is challenging the order of the honorable single judge, wherein he was not made as a party, no opportunity of hearing was given. So for that purpose, my lord, I have filed an application for seeking leave to present this appeal, my lord. That is, my lord, IA number 4832, my lord. Lord, I'm shortly, my lord, I'm giving the facts of the case and how I'm aggrieved by this order of this honorable single judge, my lord. Lord, the fact of the case is like this, my lord. The managing committee of this appellant school was formed in 1994, my lord. One Bhabagrai Das was appointed as the secretary, my lord. He has given his resignation and his resignation was allowed by the governing body. From the same resolution, my lord, I have been appointed as the secretary, the present appellant, my lord. After appointment of my lord, I have sought for one registration of society, my lord, for my managing committee, my lord. Also, the same person who has resigned previously, my lord, he has also sought for the same. Somehow he got the certificate, my lord. I have challenged that very certificate, my lord, in this honorable court. That order, my lord, I am just pointing out, my lord.
Disposal of representation, you are challenging that order.
My lord, I am aggrieved, my lord, if that reconstitution of the managing committee will be approved by the authority.
You are Bhagirathi Jena.
No, my lord, I am not Bhagirathi Jena. I am, my lord, Samir Ranjan Das of the present appellant, my lord. I was not made as a party, my lord. They say that some.
What is your status? So
My
what is
lord,
police?
I am the secretary, my lord. I am the secretary of the managing committee. But they somehow come to read appeal and read petition has confirmed that I am the secretary, my lord. But some people have come to this court without letting the court understand what is the matter, only by saying that my representation may be considered by the appropriate authority for reconstitution of the managing committee. But if that will be considered, I will be highly prejudiced, my lord. I am the secretary. I have the order of this honorable court. Now somehow they have managed to get that order, my lord.
All right, we'll examine the issue. Let us see.
Lord, only submission is, my lord, I have given one step of petition, my lord, because I will be prejudiced, my lord, if that will be approved, my lord.
All right.
My lord.
Item number 4832 of 2023. You are Mr. Das.
My lord, P. Das, my lord.
Mr. P. Das and counsel has appeared for the appellant applicant. So this is an application seeking leave to the appellant for filing the intercourt appeal, as he was not added as a party in the writ petition being WP number 20677 of 2023. So, according to Mr. Das, the petitioner being the secretary of the managing committee of the school concerned, but he was not given any opportunity to lose the relevant facts for adjudication. So by the impugned order, he has been seriously prejudiced. Stop. Having considers the statements made in this application, this interview, where the brief should be granted as according to his order. These applications are allowed and disposed of. In main appearance, admit to be heard on merit. This is an intercourt appeal challenging the order dated 14/7/2023, delivered by WPC number 202677 of. It is 2020. 2023. Admit to be heard in merit. Issue notice returnable on 22nd of September. 25th of September. Earlier it is made on 22nd. Earlier order 22 on September. Earlier is 26th. Earlier it is 26th. Now you make it 21st of September. Special service on the response shall be taken within 3 working days from today by registered post. You are appearing for
1, 2, and 3. Would them
Challenge that order because order is against you. Have you challenged that order?
But here is the order. Says that's the order clause. If what he said, this is representation has been disposed of. Sir,
that reappeal will be the
You have to challenge it by way of a writ petition. No?
Lord, they say that they may be reconstituted. The managing committee will be reconstituted. But already there is managing committee. Lord.
directions will understand.
Dispose of the Lord.
And you are saying now that the representation is disposed of.
Not disposed of, Lord. If that will be disposed of, then I'll
No,
be.
you said it's been disposed of.
What is
I have not.
Anything wrong?
It has been disposed of representation.
No, not disposed of, Lord. If that will be disposed of, Lord, I will be free.
I estimate fix it to next week so that I can take instruction on the status of that representation.
Advise them not to take any further action until we pass any orders.
Lord, my lord.
All right.
If not taken, my lord, if in
All
the
right. All right. Permission does and counsel attend to the applicant. There is an application for staying the operation of the impugned order dated such and such, first in such and such. So, Mr. P.K. Mr. M.K. Kuntial and National Government Advocate seeks a short accommodation to instruction in respect of whether the representation is asked to be considered and disposed of by the impugned order has been disposed of, or what is the status of that process? Questions allowed. Let the matter be listed on 21st of August 2023. Meanwhile, Mr. Kuntil and additional government advocate shall take the necessary instruction. Stop. If the representation is not disposed of on or before today, the official respondents shall not pass any order till the next stage. All right. 21st September. This is a retake will also make on 21st. Because otherwise it will be segregated. Retake will earlier give 21st of September. It make it retake will also on 21st of August. You take steps by speed post. This earlier the registered post, make it as a speed post. Return holding on 21st. And the interlocutory application is also by 21st will be there now. Because of some.
Item number 5. Item 5. By the order dated 2/8/2023, minors directed me to file affidavit on two aspects. Now, though I have sought for instruction, I have not received. So I pray for some more time to comply the order dated 2/8/2023.
How much time do you require?
10 days.
10 days. You provide 10 days time. At the request of Mr. P.K. Modolil and counsel appearing to the opposite parties that the matter be listed on 28th of August 2023. So the affidavit in terms of our order dated 2023 shall be filed in the meanwhile. No further accounting will be made for the same purpose. Mr. B. Raut and councillors appear for declaration.
Item number 6.
Item number 6. Minors being directed to obtain instructions in the matter. I have received the instructions.
Paragraph 6, That Nehru Satabdi Hospital at Talcher. That is going to be part of that hospital. Or those will be closed down and this will begin here. What is that? Taking the existing 100-bedded Nehru Satabdi Hospital and Talcher as part of the said hospital. That means 200 plus 100.
Yes. Because the requirement first line management in
300.
NMC norms, teaching hospital a minimum 330 bedded.
You don't have any time-bound program.
We have indicated in paragraph 6,
That I have seen.
1st October, tentative is first.
So, Ms. Jana, they have promised to make it by 1st October 2023.
Then your lordship may pass that order keeping that in view.
That is what?
Yes.
One thing MCL gave up saying it cannot do. Now the government has to do it.
By means of this public interest litigation, the petitioner has asked this court to make the medical college and hospital at Talcher functional in as much as since 2016. The infrastructure is ready for starting the college and the hospital. 2018. So it has been also asked to direct the MCL, Mahanadi Coalfields Limited, to start the said medical college under the corporate social responsibility scheme, CSR scheme. Stop. By the order dated 28/7/2022. 7/7/2023, we asked Mr. Muduril and government, additional government advocate to take instruction from the state opposite parties, number 1 and 2, about the status of the said verdict. Called Mahanadi Institute of Medical Science and Research, within bracket MIMSR, which is the venture of Government of Orissa with MCL. So, today, Mr. Mudali, an additional government advocate, filed a copy of the memorandum of understanding on a few correspondence which were exchanged between the state government of Orissa and MCL. So he was also produced before us for written instruction he has received from the Special Secretary of the Government, Health and Family Welfare Department, on 10/8/2023. In the same written statement, it has been stated clearly that in terms of the memorandum of understanding that was entered, memorandum of understanding for establishment of a medical college and hospital at Talcher on PPP mode on no profit and no loss basis. The MCL constructed the infrastructure of the medical college at Talcher as part of its CSR initiative. And thereafter, they had also asked the state government to issue the essentialities certificate for applying to the erstwhile Medical Council of India, within MCI, for grant of letter of permission to open the medical college and hospital, namely Mahanadi Institute of Medical Sciences and Research, within first bracket MIMS, with 100 MBBS seats from the academic session 2021. It has been stated that essentialities certificate was issued by the government of Orissa on 2/7/2019 in favor of MCL. But the MCL has not succeeded to open the same medical college and hospital for various reasons. At a subsequent date, the CMD MCL, by later dated 21/4/2022, requested the state government to consider taking of the said medical college and hospital. MCL had also promised to give suitable viability gap funding within bracket VGF, was the bracket, towards running the college through its CSR fund. On due consideration of the above proposal was made by the CMD MCL, the government of Orissa had decided in principle to take over the same medical college. On condition that MCL will bear the entire actual operational cost for running of the medical college and hospital in perpetuity as a part of its CSR activities, along with the additional capital expenditure for the initial years. The conditions were duly intimated to MCL by the letter of the department dated 12/5/2022. Mr. Moduli has pointed out to the para 6 of the said written instruction. It reads as follows, quote, 6. However, as per National Medical Commission, within first bracket, NMC, close the bracket, norms, a teaching hospital of minimum 330 bedded is required to be made functional for at least 2 years to apply before the NMC for grant of letter of permission to start a medical college with 100 MBBS seat. Accordingly, the state government and the MCL are jointly taking steps to functionalize a 330-bedded hospital tentatively by 31st October 2023, with taking the existing 100-bedded Nehru Shatabdi Hospital at Talcher as a part of the same hospital. Okay. Okay, but we therefore submitted that in view of the said decision is taken principally by the government of Orissa, this petition may be disposed of. So, Ms. Sujata, General and Counsel appearing for the petition has immediately agreed to the proposition and asked this court further that it is not that according to the deadline as provided in para 6 of the written instruction, the hospital shall start functional with continuance of development of the advanced infrastructure of the state hospital at the financial support of MCL. Stop. Whereas the government of Orissa and MCL have agreed to start the hospital by 1st of October 2023. We direct the state respondents who have taken the responsibility of the running the hospital, being duly financed by the FCL as their CSO activities. We direct them to ensure the opening and functioning of the hospital from 1st of October 2023. And thereafter due process shall be followed for make the medical college functional. So, in terms of the above, this petition stands disposed of. A copy of this order be supplied to just this last two lines in little restart. So because you say you can start the medical college and hospital functional. That is confusing because the National Medical Commission says that only after you make the hospital functional
at least for a period of 2 years. Thereafter, we can apply.
No, because now that is why it is not confused because you start functioning of the medical college because the hospital that you have purpose it is an old hospital.
First line of paragraph 6. As per NMC norms, a teaching hospital of minimum 330 bedded is required to be made functional for at least 2 years to apply for the NMC for grant of letter of permission.
Yes.
So it has to continue.
No, just the hospital. Okay. All right. That dictation will remain there. Only part of the dictation will remain. Okay.
Please, my lord, urgent copy of your lordship's order.
A copy of this order be given free of cost without counsel of the parties. The written instruction dated 10/8/2023 as produced by Mr. Mudali Nation Government Approval is taken in the court. Yes.
Item 7.
My lord, public interdiction from eviction of the government hospital, the veterinary hospital, and to the operate number 6 and 7. And earlier, the petition came to this court that directed to add them party who were enclosures, my lord.
Is the government land?
Yes, my lord. It is veterinary hospital land, my lord. Annexure page 17 I also made a representation to the collector and the other officials, my lord.
Annexure? You who sees is your representation?
My lord, to Tahsildar, collector and
yes.
Electronic report.
the seal faster seal. It is the receipt.
Yeah, Mr. Das, Sharat Kumar Das. Mr. What is inside the hospital?
That seems to be inside the campus. There are some slum dwellers are possibly occupying. That is the.
So we direct that this to just consider the facts narrated in the representation and start the appropriate.
Tahsildar may be direct.
Tahsildar.
Yes,
The appropriate proceeding may be started.
Yes.
Heard Mr. Saroj Kumar Das and counsel appearing to the petitioner. This is a public interest litigation seeking direction of the appeal department 3. It is a collector will be the better person. Do it through the Tahsildar.
My lord, in fact, this is in Rourkela, and Rourkela is mostly administered by the ADM. Rourkela, there is a ADM. If Tahsildar or sub-collector will better, Sundargarh collector is sitting in Sundargarh. This is Rourkela, so better for the convenience of the petitioner, the Rourkela
Tahsildar, all right. To direct the opposite party number. No, they have to evict the opposite parties numbers 6 and 7 and other encroachers by demolishing their construction over the plot number 205, Khate number 2, measuring 5.895 acres under Moja RTU -42 under Sundargarh district. Stop. It has been also stated that the petitioners have filed representations seeking the similar relief, but no action has been taken on the state representation. So the petitioner being a petitioners being public spirited person have taken this action seeking eviction of the squatters over the government land by constructing semi-permanent structures. So the photographs of the structures have also been enclosed with the writ petition as Annex 4. So, without observing on the merit of the case or the status of the opposite party number 6 and 7, we direct the opposite party number 4, Tahsildar Rourkela, to look into the allegations made in the representations within bracket Annex 2 series to the writ petition, to this petition, and take the appropriate action as warranted in law. Stop. The opposite party number 4 shall pass an reasoned order only after affording opportunity of hearing to the opposite party number 6 and 7. Stop. The petition, one of the representatives of the petitioners may also be allowed to make their submission before the respondent opposite party number 4. So, for purpose of disposal of the representation, we provide the Tahsildar 8 weeks' time from the date when a copy of this order will be furnished to him by the petitioners. In terms of the above, this petition stands disposed of. A copy of this order be supplied free of cost and D.K. Mohantila, Additional Government Advocate, appearing for the opposite parties number 1 to 4. Or 1 to 5. Stop.
My lord, may I point out one thing? Your lordship may see, he has described opposite partner 6 and 7 as encroachers of this particular land. But kindly see the address mentioned of, they are staying in a flat, that is the address. In a flat at Basanti Colony, opposite partner 6, another is also at Basanti Colony, Rourkela.
Whatever the allegation, you have not made any comment.
No observation is made. Only want to point out that how the petitions are being filed.
No, that is why. Because if you do not give the proper address, you cannot get the proper result also ultimately. Public if litigation is become an instrument of holding the newspaper headlines, One day that efficacy will go away. Nobody will give any importance, not the administration, not the people at large. Will not give any importance to it.
According to him, they are staying elsewhere near Basanti colony.
Maybe because they are occupying for other purposes. That let the Tahsildar
Yes.
into the take a decision.
Item number 8.
And accordingly, she has submitted a memo seeking the withdraw this petition.
Yes, ma'am.
Just you file, it's taken on.
The copy of that statement.
Not statement is even recorded in the police.
Only the statement is there, my lord. It should have been in a different paper. I'm sorry, my lord.
All right, okay.
The pen-
Just you can see it.
My lord. My lord.
Otherwise, you can also give this copy. There is no harm in it.
I'll give it
I'll
up.
just take it.
For my client satisfaction, actually.
You have to submit for the client.
This is there.
Pardon, my lord, pardon.
We find no impediment in granting leave to withdraw the petition at this stage, and accordingly, this petition stands dismissed as withdrawn.
My lord, obligement.
The written instruction as produced before us is taken on record.
Item number 9.
Item 9, my lord, despite of my directions, maybe despite our influence, the department is not responding.
Yes.
This telecom department said that is taken by BSNL. BSNL is not, if they are not responding any manner, we have sent the mail by, also sent the letter order of the High Court by post.
All right.
That is on 18/7/2023. We have and copy of the same also sent to the general manager telecom.
Yes. We restored the petition. You are Mr. Mahapatra?
Mr. Samarendra Bora.
All right. Lord Mr. Samarendra Bora, Lord Counsel appearing for the petitioner applicant. Also heard Mr. P.K. Pari, Learned, Deputy Solicitor General of India, appearing for the opposite party number 2. No. Sorry. So just have you any objection to that?
Your Lordship.
Why?
Your Lordship, apart from the condemnation of delay, Your Lordship, on the last occasion, the Lordships have directed as a last opportunity to pay a cost for the condemnation of delay. That has not been made yet. And
You will be paid.
That's why I'm saying, madam, they are not.
Your Lordship, the department.
We will be restoring it subject to payment within 30 days. Otherwise, it will be automatically dismissed.
Yes.
Within 30 days. That will be direction. 30 days they will. No, they are not getting communication. Try to understand their difficulty also. Huh? I heard Mr. P.K. Pari started things.
Along with Mr. Jateshwar Naik.
It's Pari, Deputy Solicitor General of India, along with Mr. Jateshwar Naik, CGC for the applicants. So this is an application for recalling the order dated 9/1/2017 by which the resolution was dismissed in terms of the preliminary order dated 10/10/2006, passed in WPC number 9582 of 2004. It has been pointed out by Mr. Beva, huh? It's a research, when counsel appearing for the opposite party number 1, that at the time of condoning the delay, this court had imposed a cost of rupees 5,000 to be paid within 15 days from today. But no such payment has been made as yet to the opposite party number 1. Mr. Pari, when the counsel, the deputy SDI has submitted that for unknown reasons, the applicants have not communicated them. So, Mr. Pari, it is also asked for extension of the time for the said payment. So, we are really unhappy the way the applicants are behaving. Stop. We, in the circumstances, we think it will be appropriate to recall the order dated 9/1/2011, which was passed in terms of the preemptory order dated 10/10/2006. Subject to payment of the said cost within a period of 30 days from today. Stop. Let the matter be listed on 13th of September 2023. If the said payment is not made by 11th September 2023, these orders be automatically vacated and the order dated 7/1/2007 passed in terms of the order dated 10/10/2006 will survive, meaning the writ petition will be treated as dismissed for non-payment of the said amount. Stop. In terms of the above condition, the order dated 9/1/2007 and order dated 10/10/2006 are recalled. Stop. This petition was disposed of. I've made it clear, automatically the order will be dismissed. On that day that you just point out, the payment will not be a formal order will be passed. We have passed on merit order.
Not sure.
Right.
Item number 10.
Yes.
I have been filed. The loss may family 1866/2008 for modification of recall of the order dated 23rd June 2023. Flag E loss, flag E.
23/6/2023 order.
23/6/2023.
Yes.
Para 4 of the case kindly see. 6 now he is in trouble. Any pray before your lordship. Any submission made by the council. He may be excused. Another part of the order, unconditional apology, he asked for the council. And he pray for small modification of that order. Just to take adjournment, he just submit slip of tongue. That file has been taken away by the appellant. That is the only reason we filed this IA. for modification of lordship's order, my lord.
Only technical aspect is that was a special bench whether can come through because it's a modification or recalling the order. So your lordship sitting with Justice Satpathy, so very well available. So that I think lordship, all right, a special bench.
This matter on 16/8/2023, before the appropriate bench. Registered judicial is directed to place the matter on the administrative site for necessary approval.
My lord, in the meantime, the proceeding has been initiated, that may be kept for.
Any order we cannot pass, we will come on 16th.
I pray, my lord, 17, my lord. Only.
Although we can also 27th, we have no difficulty.
16th.
All right. 16th. Mr. J. Katoki, sounds like the name of the council.
Item 11.
Yes.
Item 11.
Whether Mr. P.K. Patnaik, Prashant Kumar Patnaik is attending the court nowadays?
Yes.
He is attending the court. The
Yes, my lord, is coming.
is coming. You have seen yesterday or day before?
Last 2 weeks I have seen him.
All right.
That man is from Bhubaneswar. Sometimes he comes.
Yes. This appeal is barred by limitation. Opportunity barred by limitation. And that objection has been recorded in the assessor, but no step so far has been taken. By the order dated 13/3/2023, this court has extended the time on the ground of the unwillingness of the learned counsel appearing for the petition. Since then, another 5 months have elapsed. Almost 5 months have elapsed, but no step is there. As we have reasons to believe that the appellant is not interested to prosecute the appeal. Accordingly, the same stands dismissed as not pressed. Therefore, dismissed for non-prosecution. Mr. M.K. Kunchi, Planet Council, Planet Additional Government Advocate, was appeared for the opposite parties.
Item 12.
12 can be taken up after 2 weeks. In the meantime, I will different remove my lord.
Just a minute. Mr. Pampi appears for the opposite parties, number 1 to 4. What is your prayer, Mr. Counsel? You are Mr. Mishra.
No, my lord. Tushar Naik. Tushar Naik. Now, already notice already been issued. Last order can be similar. But the file is not with me, my lord.
Or the council and file is not with you.
File has been misplaced, madam.
Notice was issued according to you.
My lord. Last order condition.
All right. We're giving you a last chance, but it will come on 17th of August.
My lord.
17th of August, it will come.
My lord.
But if the steps are not taken, we'll dismiss your petition on the next date.
My lord.
At the request of Mr. T.K. Nayak, counsel appearing for the appellant, let the matter be listed on 17th August 2023. Meanwhile, the defects as pointed out by the registry shall be removed. Else, will be perceived to pass an order for non-prosecution. Mr. Kuntia, are you appearing there?
Yes, you let me see what is the order. The 219 page. So, Honorable Single Judge are directed to ventilate their grievance. So that is
My lord, similar set of play already filed the self-benefit. And in that case, already case admitted and notice already issued.
next thing.
But in my case, we need to approve it. That is the.
But you are not interested, matter is pending since 2 years.
Even if there is any judgment, if what he says, annexing that judgment, he can file a representation. Perhaps there is no error in that. Or
Out of 200 peoples, 100 peoples have filed the case. And in that case, single judge admitted the case and notice also issued. And already I have seen that order. But my case, only to approach for the without approaching for the authority, you come directly to the court and your case is not important. That is the order. In this similar cases already been pending. Already I have given the numbers.
What is the impugned order?
page 219, my lord.
My
lord.
You did not file any representation? You did not file any representation.
My lord.
How you can come to the court? Tell me. What is the wrong in the order of the learned single judge? Simply because someone has filed the writ petition, that will not give an individual rights to approach this court. You have to place your demand for issuance of the mandamus. Without the knowledge of the government, how can decide the government is not in your favor? Your first duty to just place your demand before the government. You know, as a counsel, even in the civil suit, there is a compulsory requirement of filing a suit against the government. You have to address a notice under section 20, subsection 1 of the CPC. And only in a case of serious urgency, leave can be granted for directly suit. In these cases, there is no serious urgency. Mr. Counsel, it is better these other petitions are still pending according to you. File a representation to the government and file a fresh petition. Don't complicate the matter unnecessarily. No matter has been passed in this matter. So there is no existing right in your favor also being similarly situated.
My simple lordship, this matter can be taken with that matter.
You cannot, because you have not discharged your own obligation. You have to give the demand to the government that you do this, otherwise I will go to the court.
And that observation,
that is the legislation is already there. Make this observation.
So some of the employees have filed the case. That is the one say.
No, that you just know that is a matter of facts and.
Already I have noted, edit repeats.
I'm recording, all right, I'm recording that, that is your submission. All right. Mr. T.K. Naik, just throw the audio for the repeating. Then counsel, appealing for the appellant is submitted that on the similar prayer, the writ petitions being filed by the similarly situated persons are pending before the single judge. But the petition of the appellants has been dismissed by the order dated 21/2021, holding that that instead of filing a detailed representation before the competent authority for consideration of the issue involved therein, the petitioner has straightway approached this court. Stop. Unless the writ petition has been dismissed. Stop. We do not find any infirmity in the said order dated 21/2021. Stop. As such, we dismiss this appeal at the threshold, granting the liberty to the appellants to file the representations to the competent authority, and on the basis of the outcome of the representation, to approach this court by filing a fresh petition if they think that would be appropriate for the remedy. Stop. No order is to cost. Mr. M.K. Kuntial and counsel is appeared for the opposite parties, respondents. All right.
That representation to be considered within times to go.
You have not filed the representation. Court will directly with such and such. Sorry. This cannot be done by the court. File representation and then not disposed, then come to the court.
Item number 13.
Yes, good morning. Actually, determination filed with the order dated 18/5/2023. I have filed appeal on 31/5/2023. During time, but the certified copy not filed, that's why delay has been occurred, my lord. Though I have filed website copy, my lord, now I have filed certified copy.
You have filed the certificate copy?
Yes, my lord. That's why you also directed me to file a limitation petition.
That you have not filed.
I have filed, my lord. That is today. I number 7733.
Who is appearing for the? What is the BPCL?
Bharat Petroleum.
Why do you write the short name?
Sorry.
Okay.
Sorry.
All right. There is, but in the interim application, you have written only BPCL. All right. Mr. B.R. Swine, learned counsel appearing for the appellant applicant. This is an application for condoning the delay of what is the call for the condoning delay in filing the intercourt appeal? against the order dated 8/5/2023 by the London Civil Judge in WPC number 11056 of 2018. So issue notice as to why the aforementioned measure shall not be condoned or any other order or offense shall not be passed. The appellant shall take steps for service of notice on the opposite parties within 3 working days from today by registered post 8/18. The notice is made returnable on 21st of September 2023. So you take steps within 3 days.
Okay, no, free. I'll take a notice by way of special message.
No,
Because long in this case, yes, I wait notice.
that goes against you again.
All right. Well, as a document.
All right.
Item 14.
May I please? Second, filed by the student. Yesterday, I have filed an affidavit on behalf of the appellants, enclosing the copy of the writ petition and the counter affidavit. It was not filed along with the writ appeal, and a copy of the letter.
All right.
I have filed 2 IAs. One IA for dispensing with filing of the certified copy at flat A, and flat B is the IA for condonation of delay of 333 days.
So what the parties there?
Yes, we are the parties. We have filed the
One party. The writ petition is the only opposite party.
yes, one. So less.
Are you appearing for the respondent?
Your notice not issued, I saw what appeared for the responding one.
You filed the Bagalatnama.
Yes, madam. Proceeding that disclosed the rate of is filed.
What is it?
wireless
Just to find out whether the Bagalatnama has been filed from the records.
On 28/7/23, I filed an affidavit including Telangana Ratho.
Yes. Mr. Malik, whether you will be opposing this delay.
Yes, madam.
So you file an objection. You file objection against the prayer for condonation of delay. Would you like to file any objection against the prayer for condonation of
No,
it is 334 days delay. About a year.
yes, madam.
All right. Mr. So you have to issue notice. Mr. P.K. Meduli.
Tomorrow the content is posted.
All right, that will take care.
Even on moral also can decide it, my lord. Because
Then you have to accept that I will not oppose the condonation of delay, then we can go to the marriage.
yes, I will do.
You agree?
Yeah, I agree.
Mr. P.K. Meduli, this is IA for 4126 of 2023. No, sorry. It is 4128 of 2023. This is an application for condoning the delay of over 334 days in filing the intercourt appeal from the order dated 15/7/2023, filed with the London Civil Judge in WTC number 6609 of 2022. Mr. Malik, London Council appearing for these sole opposite party has stated that opposite party has stated that the said opposite party will not oppose the prayer for condemnation of delay. Stop. On the basis of the said statement, we condone the delay as aforementioned. In the result, this application stand allowed and disposed of now in the appeal. In view of the order passed today, such and such, such and such, we take up this appeal for consideration. But Mr. Siddesh and Mr. P.K. Muduli, Learned Counsel, appearing for the appellant. So Mr. Muduli has filed today a set of records containing the order dated 4/1/2017, the copy of the first schedule of the ORSF rules 2008, copy of the writ petition being WPC number 6809 of 2020, along with and copy of the counter affidavit as filed in WPC number 6809 of 2021. Those are taken on record. Stop. Mr. Muduli Learned Counsel has submitted that by the said order dated 15/5/2022, the appellants have been directed
to finalize the pension of the respondent by taking into consideration the grade pay of 4,200.
Applies the payment of the opposite party number 2, right? No,
Respondent number 1.
respondent number 1.
Paragraph 7 and paragraph 10 of the judgment of the honorable single judgment. Clarified everything.
On account of his retirement benefits along with interest within a period of 2 months from the date of the order. Stop. The appellant has challenged the said direction contending that what is your main contention?
Main contention that the points which were taken in the counter affidavit, denying the benefit to the present petition, that has not been taken into consideration. Specifically, my lord may kindly see the main contention raised in the writ petition was paragraph 8. That has been elaborately dealt with in paragraph 13 of the counter affidavit.
Right.
My lord may kindly see. My lord, first see this additional affidavit today which I have filed today.
You straightway come to the counter affidavit which starts from page 22.
Yes, please. Page 32, my lord, we can see paragraph 30.
Yes.
That in reply to the affirmance made in para 8 of the writ petition, it is submitted that as per the clarification on revised
Is what in the para 32?
page 32, internal page 7, para 13(1)(3).
Internal page is 8. Now you are referring to internal page 7.
Yes, ma'am. Running page 32 of the
So
affidavit.
7 is a running page 29. Then in reply to the governments.
Yes, in reply to the affirmance made in para 8. That is paragraph 13 of the counter, 1(3).
Yes.
That in reply to the affirmance made in para 8 of the writ petition, it is submitted that as per clarification on revised assured career progression scheme for the state government employees by government of Odisha in finance department memo number 21/2014 or serial number 4, but there are less than 3 promotional posts in the cadre, the employee of that cadre shall get the pay band and
Containing that all right. That as per clarification on revised assured career progression scheme, RACPS, for the state government employees, by Government of Orissa in Finance Department memo number 1738/F dated 21/2014, serial number 4 dash quote, where there are less than 3 promotional posts in the cadre, comma, the employee of that cadre shall get the pay band and the grade pay of the promotional post within first bracket S up to the stages available in that cadre, and thereafter the next higher grade pay along with pay band hierarchically available in first schedule of ORSP rules 2008, with introduction of new grade pay, if any in between shall be given. It has been also stated as a matter of ground in this appeal that in Orissa Fire Service, there are 2 filler posts, comma, one is fireman and the other is station officer. In accordance with the said clarification and RACPS rules 2013, those personnels appointed in the rank of firemen were eligible in the grade pay of rupees 1900 and maximum grade pay of rupees 2200. But due to misinterpretation of the above rule, those fire service personnel who had completed 30 years of the qualifying service, they were allowed the grade pay of rupees 4,200 under the third RACPS instead of 2,400 or 2,800. According to the pension papers submitted to the Accountant General INE, Orissa Bhubaneswar. Initially, AG Orissa Bhubaneswar sanctioned pension in favor of the 40 retired fire service personnel belonging to the Central Range cutoff without any objection. When the similar proposal came out in the month of August and September 2017, the AG within bracket A and E Orissa Bhubaneswar for the first time returned the pension papers of the 6 retired fire service personnel with remarks that they are not entitled to the said scale which was granted to similarly situated person. Stop. According to the respondent number 1,
That have replied, resume the paragraph 6.
according to
So one more paragraph is the next page.
according to the appellant, yes.
In view of the above circumstances, new pension is that is.
Next page.
Page 34 running page, internal page is 9. Of paragraph, in view of the above circumstances.
Your presentation and our presentation doesn't tally. What is the line? First line.
Yes. First subparagraph, in view of the above circumstances. My lord was holding page 8, internal page 8. Just the next page.
9. I'm looking at 9.
Yes, 9.
Also, it is further stated by Mr. Muduri that in view of the above circumstances, new pension basis after August 2017 could not be finalized further. It is further submitted that those retired personnel have been sanctioned pension at considering their grade pay, not at 4,200. and those are not regular. Subsequently, the steps taken to finalize the grid pay to finalize the grid pay issue, but due to filing of on the writ petition against the orders of the government, the same could not be resolved. Besides, it may be that about the same negative equality cannot be made the base of the relief by the respondent number one. Stop. Be that as it may, we think the reasoning as given in the impugned order request to be revisited. Accordingly, admit the appeal to be heard on merit. We are fixing the matter because they want to settle the matter on 21st of August.
But those appointments have replied in the rejoinder file.
This is material for purpose of admission. You reply in the full-fledged hearing. We are fixing the matter on 21st of August this month. On 21st of August. So, yes, Mr. Malik has appeared for the sole respondents. We have not issued a formal notice. Have you got the memorandum of appeal?
No.
Mr. Mudali is requested to supply a copy of the memorandum of appeal to Mr. And respondent number one, Mr. Malik.
I have filed an IA for stay. The contempt has been filed and it is posted to tomorrow. That order, my lord, the affidavit, you will submit and see the affidavit filed by the respondent number one at flag B. My lord, flag B.
Is
page 9.
Flag B, there is a condemnation petition that we have disposed of already.
Flag B.
Yes,
Is page 9. Like the order passed in contempt case fixing the date to 11th August. And prior to, there are two orders wherein our applications for adjournment has been rejected.
Next.
All those petitions may be copy,
this 21st, I was say the court that appeal has been admitted. Contempt proceeding will not be done.
The proceeding has been initiated by the respondent number one, and my lord senior is also the counsel.
No, it's all right. You tell before that court, the appeal has been admitted and slated on 21st. I don't think any court will proceed further. Tell that we are fixing on 21st. All right.
My lord senior also should cooperate so that if not,
Definitely will cooperate.
Item number 48. Well, in the second matter, there is also delay. Notice has to go into.
There is also delay.
Yes, ma'am. 280 days.
I-4589. Same way, delay is 281 days. Notice made returnable on 21st of September 2023. Postal service, 20 working days. Register post availability. Here also you have asked for the stay.
Yes, ma'am.
Stay will not be granted by us. We simply issue an IA such and such 4.90. All right. Mr. P. Mudali and the council appearing for the appellant. There is an application for staying the impugned order dated 13/9/2022 delivered in WPC OSC number 2806 of 2018. Issue notice returnable on the authority is permitted to take steps on the opposite party. Opposite parties. So we still supposed to within 3 working days. A lot of parties are there.
Yes.
Within 3 working days. All right.
Item 53. Item 53, my
Lordship, it's at 12, 48.
Just we are taking first 48, then we'll.
Then 50, obliging. Item number 48.
The petition for conditional delay, I have stated why there is delay. Lordship will kindly view the decision of the review court that dismissed the review, but put an observation that I have challenged. And I also tried my best approach the learned single judge and the honorable single judge disallowed my prayer for expansion of the observation by order 11/4/2023. And after the dismissal of the review, dismissal of the review,
Yes, go ahead.
I mentioned for listing of the analogous petition filed by the employer company, that is the respondents, then that on that date, on 28/3, they came up with a petition for withdrawal of the WPC to pursue an appeal in terms of the observation that is included in the appeal. So thereafter, I immediately filed on 29/3 and a petition for expansion of the observation before the honorable single judge who dismissed the review petition, but did not grant any liberty, only and the impugned observation if the employer so chooses or so proposes after the statutory period, they have filed the appeal. They have the mentioned. So on 28/3, the honorable single judge dealing the analogous petition dismissed the petition filed with the employer as withdrawn. And immediately thereafter, on 29/3, I approved the honorable single judge. That this observation has created a lot of problem because despite the bar of the review court resolution, they were dismissed and neatly stated all reasons why it is dismissing the board. And that other was here on 4/9/17, they are sought to be revived. That is sought to be reviewed, to revive. But that observation has created given a handle to the employer to final appeal. That also is stated.
Yes.
And that also has been also closed because the honor signature on 11/4, which are appealing
For the
Respondent 1 euros.
is the employer.
Can you take up the matter and merit?
Lordship, a copy of writ appeal has not been supplied.
Supplied to them.
Sir, we do not admitting, but at this the threshold we will decide the matter on merit because it's more issues involved in it.
Yeah.
We request Mr. S. K. Mohanty and counsel appearing for the appellant to supply a memorandum of appeal to Mr. S. Pradhan, no?
A Mishra.
Aditya Mishra, yes. A Mishra and counsel.
1 and 2.
Copy of the party number 1.
Could you also sort
Yes.
No, all right. Have you not received copy?
No.
Is it below on some? It's all right. Yes. Okay. But no. We are taking both the appeal and the delay condonation petition because we find there is a merit.
Yes.
We are projecting that we will condone the delay by convincing the parties and decide on the same day. Right. And then
Another petition I have filed must go to second appeal.
for the respondents number 1 and 2 and Mr. P. K. Muduri additional government advocate appearing to the respondent three. By tomorrow, in course of the day. Office in their office. The matter will be listed on 14th August 2023. 14th August.
Like at 2 p.m. Because after 9 was returning, and he was having a second appeal. First appeal was closed. In terms of the order. He has filed second appeal. And it posted to 5th of August last. And I have a petition. And the appeal was been agreed strangely without noticing me, without causing delay, and without telling of statutories. Everything is going irregular. So I am 70 years old. How many years I will survive?
Already we are fixing the matter on 14th August. Very unusually we are fixing the matter on 14th August.
Yes, possible. We also have to fix a time here. I will be high.
It's not possible.
Yes, I will.
No, that is to get the matter on the day. Also mention if our both promise you definitely agree with the matter. You just mention on the day.
Lordship, I have rendered appearance for respondent number 1.
Yes, fine,
Not 2. 2, your Lordship, actually chief executive officer, there is no such post. But being the company, I may be permitted to reply.
No, that is why but some chief executive operating officer or an executive officer must be there.
No, I have appeared for MD.
The transfer to Tata still non products. And the library is still
of the same company. So you just that is the possibility. He pointed out that there is no such provision, but because the company's officer has been shown, I have admitted. Sorry, appeared.
I will find a copy, single copy for the parties 1 and 2.
That will be.
HON'BLE.
Also, supply a copy to Mr. Mudali also.
Yes. Item number 53. Please, your Lords.
Yes.
But this is regard to that Baravati Palace inside the stadium campus, Baravati Stadium.
We have affidavit with Mr. Mudali.
We have received the copy on 8. So I think in the morning my land friend was asking for time to file the rejoinder because the document what they have filed if a lordship should just have a
Mr. Mohanty, that we somehow, it is a mistake over the registry. Your affidavit is not in our compilation.
E-filed,
E-filed and hard copy is also filed. Lordship, hard copy is also filed.
Okay. Paragraph 17, I think very important. Just look at the paragraph 17.
These commercial shop rooms are not in dispute also.
No, there was no. That is you are on the earlier occasion also your point.
Yes, my lord. This is only regarding that mandap. And the document that they have filed, which is in the vernacular language, I don't know if it translates.
That is only record of right in respect of that is the downloaded copy of the ROR.
It doesn't show where it reflects Baravati Stadium and the Olympic Association. Because where they are trying to that is where they want to show, which is at page 13, where it has been marked. Or only place where it is shown as Dakhal Orissa Olympic Association is at page 12. If your lordship should see page 12, the 5th item up from the top, the total area is 0.002 decimal, which is roughly, if calculated also in terms, is about 800 square feet. So that they say belongs to the state government, on which Olympic Association has the unauthorized occupation. Whereas the Olympic Association or that mandap is built on more than, I think, 30,000 square feet or 40,000 square feet of land. That is one part, my lord. What they have also referred in their affidavit, if your lordship should see, they rely on 2 paragraphs of the Honorable Apex Court's judgment, which I have annexed.
Yes.
If your lordship should come to first, para 34 they rely upon. They've selectively done so because in other places there are different findings are there. But anyway, I'll just, which is at page 54, if you like, 6 of time. Where the entire record has been described.
Yes.
And my lord, then if your lordships may come to.
You see the last part of the paragraph 8. Where you are mentioning that the decision of the apex court.
Yes, my lord.
Last part in page 4 of the counter affidavit.
Page 4 of the judgment.
No, they are counter affidavit.
Counter affidavit. Yes, my lord. Yes, my lord. I have also marked it.
The
Honorable Apex Court, while permitting its exemption by state government, allow its use for the same purpose. But I have also marked it because it says for the same purpose. And the reasoning being, earlier the revenue sharing was there between the private company and the Olympic Association because of the construction and everything, which has been lucidly detailed in the Supreme Court Honorable Apex Court's judgment. So it has to be used for the same purpose. Now the purpose has changed. That's one part. I'll come to it later on, my lords. Otherwise also, what the land they have filed the record now says about 800 odd square feet of their revenue land, which has been under forcible occupation of the Olympic Association.
Yes.
Insofar as the shop rooms are concerned, there is absolutely no dispute, neither we have also to that extent.
Now, if what the government is projected that they will start the Mission Shakti project there, that is the area of your dispute.
Yes, yes. And that is inside the campus. Apart from anything else, my lordships understand, once there is a market complex inside it, there are sporting events being held.
On the very first day, so far I recall, I maybe not correct also properly recalling it. Mr. Mohanty just pointed out this is not the part of the sports activity.
No, activity is one part because Olympic Association is a self-sustained body. It doesn't get any aid or funds from the state government at all.
But they also are not having the license to occupy the government land without permission.
No, that portion, why the problem arises because instead of the issue being referred to the Honorable Apex Court, where the citation was given to the entire matter was decided of the title suit by the Honorable Apex Court, saying that this land can be used by the state government.
Yes.
But for the same purpose, that also has been mentioned.
What is the purpose there?
Well, purpose is the funds.
State government can serve the purpose of the Olympic Association.
Yes, fund generation and sharing with the Olympic Association. Because that was what the earlier arrangement was.
Show me from the judgment.
Yes, my lord. I'll just come to you. If your lordship should just come to page 78. Running page 78 of the brief, that is, my lord, page 55 of the judgment. Your lordship's got.
We have not got.
I'm sorry.
We got page 78 in the compilation. I'm not getting it.
Cool. The appropriate party to give the explanation could have been the Olympic Association, but since it has not been noticed. But anyway, my lord.
Yes.
Page 78, your lord.
Yes.
Para 43. Thus, two aspects are clear. One, the association encroached upon the property of the state government and built 23 shops, and the report of the committee would reflect Kalyan Mandap stands partly on the government land, and second, the property that stands on the government land has to go back to the government. There are two options with this code, that is to issue a direction for demolition of Kalyan Mandap and direct government for resumption of that part of the land belonging to the association where the Kalyan Mandap has been constructed. It is beyond dispute that Kalyan Mandap is functional for more than 2 decades. There is no justification to direct demolition of the same. It would be appropriate if we direct the land on which Kalyan Mandap is constructed to be reserved by the state government, and Kalyan Mandap should waste in the state government and shall be managed as it is presently managed by the district collector Cuttack. Then the lordships may see. Then my lord, if your lordships would see from starting from paragraph about 44, the audited accounts, everything showed how the revenue sharing was being done. And then the lordships may come to page 101.
Is 101 is a part of the judgment or outside judgment?
No, my lord, within the judgment, what I said, my lord. Page, internal page 78 of the judgment, which is at running page 101 of the brief.
Can you give us this paragraph number?
Paragraph number 55, my lords. So lordships, I can give the hard copy of it so that
Just show me the part. Yes.
Lord,
In view of the foregoing analysis,
in view of the foregoing analysis, we arrive at the conclusion that the suit land, wherein 23 shops have been constructed and rented out, belongs to the state government. But a part of the Kalyan Mandap is built on state government land, and a portion of it is on the leased area of the association. But the association could not have constructed the Kalyan Mandap in this manner, and therefore, the portion of the land deserved to be resumed by state government, but the arrangement entered into by the association with Messrs. Inc. Associates is absolutely illegal. And there is conflict of interest since the secretary's son and son-in-law have been inducted as partners in the concerned firm. And there is revenue loss as the audit report of the Accountant General is appreciated, that the secretary of the association could not have been instrumental in unauthorized construction on the government land and in generating revenue therefrom. But there is a serious concern about the nature of revenue generation, utilization, and the loss sustained, that the whole thing makes us feel there is something rotten in the management of the affairs of the fiscal aspects. Having so concluded, we issue the following directions. The collector shall take over the possession of 23 shops on the Kalyan Mandap. The Department of Revenue shall be entitled to continue the tenancy and maintain the Kalyan Mandap and manage the affairs of the said property through the district collector. No tenant anyone shall be entitled to institute any litigation against this property involved in the appeal arising from title suit number so and so. The government, if it decides to manage the properties by entering into fresh agreement, is at liberty to do so. The agreement between Messrs. Income and Associates is declared as null and void. As the conflict of interest is obvious, the secretary who is accountable to the public has failed to conduct himself required under law. He is debarred from contesting for any post in the association. Keeping in view the report of the Accountant General and the grave doubt that emerges with regard to realization of rent or otherwise, as we have already indicated earlier, there has to be an investigation, and accordingly, It is directed that CBI shall investigate into the matter, keeping in view the report of the accountant general and other aspects which pertain to 23 shops and Kalyan Mandap. If anything ancillary is required, it is to say that the investigating agencies can look also into these aspects with the registrar director so and so. Then the report was placed by the CBI before the Honorable Apex Court. Then the order which was passed accepting it was at page 106.
Wait, this area is mostly covered with the Kalyan Mandap.
Yes.
But Supreme Court says that collector can take possession of that Kalyan Mandap.
Yes, so that does not take position. That becomes position. So that aspect of which position should be.
At liberty to do so.
Yes, ma'am. We don't have
So this part, there's a clause, condition 4.
yes, madam.
Is at liberty to do so? So they are.
The agreement means regarding the tenancy of the Kalyan Mandap.
We don't know.
Well, that is what it falls because
For encouraging the women entrepreneurs, small women entrepreneurs. How can you say that you can shop? They should be allowed.
What I am saying, the judgment where the lordships have said that para 56, it has to be composed as a single flame from the same direction.
No.
And apart from that, the CBI has clarified that there have been malfeasance so far as the financial aspects are concerned, which was accepted by the Honorable Apex Court.
No, we are not going to analyze that.
Yes, my lord.
Guided by this thing and find the clause 4 really authorizes the government.
Why the problem, I must point out the practical aspect of it. Once it is inside the campus, and there are any activities because
sorry, perhaps you are going beyond your limit.
No, that is
your activities have been squarely stripped by the Supreme Court and say, no, your entire effort is a null and void. And given
that's Olympic Association and not me. It should be for
you are a conduit, Mr. Nand.
That it has to be, that's why we said when last occasion, Justice Ratha, what about the other places where the functions are? I said, we are absolutely no objection that is to be taken for the purpose of sporting purposes only.
Where have you been so far, so long? When the unauthorizedly by the Olympic Association, you were silent.
That has been given a clean check. That is one part. The second,
What has been given a clean check?
financial.
That it is being used for non-sporting activities.
No,
Clean check.
That is so that the financial work, the direction was given by the Honorable Apex Court. So our concern only is that it should be for the sporting purposes or allied purposes where if at all, that it should generate funds for that purposes only.
In a single amendment in your petition, that so long the space was used for any sporting purpose.
No, that cannot make an amendment.
Let the government do
this against practical aspect.
We all acknowledge that, but at the same time, livelihood is also very important.
I just read 2 paragraphs of the judgment. If you also that Kishan Gera had given the copy also. Last week.
2011. Okay. No, it's there. Skin and that it just below. Yes.
They can access to para 25. It starts with the Parliamentary Standing Committee. Replacement.
Yes.
The Parliamentary Standing Committee on Resources Development has noted this in its 185th report on promotion of sports in India. 5.12, underutilization of infrastructure. Optimal utilization of our existing sports infrastructure has also been one of the areas of concern before the committee. We have erected huge stadia and other sports infrastructure.
This judgment, how you apply this judgment, because you have admitted just few minutes back that it was never used for the sport.
That's what we say that.
It's supporting you, it's against you.
It's not I read the subsequent paragraph.
No, it only says the infrastructure developed for the sporting activities or the sports complex cannot be utilized for any other purposes, number one. And they say that it is underutilized, it should be properly utilized.
And where underutilization or proper utilization is concerned, it's two paragraphs.
Para 26 is the important.
Yes, my lords.
It is not for any recreation club also. It is for the nation.
No, para 27. Even these two paragraphs, if you lordship may just have
Exclusive sports stadia and the multipurpose community arenas. Under these categories, this land doesn't come.
No, that is what that it should be for.
Policy maker, sorry. That the people will come say this is to be used only for this purpose. Then we elect the government. Let them discharge their duties also.
Sorry, they can always have different areas for different purposes.
Because we understand why you are filing the public interest litigation. We cannot be the part of this kind of activities. Sorry. Heard Mr. D. Nandal and Council appearing for the PP Nandal and Council appearing for the petition stated by Mr. SUBHASIS for the petition and so by means of this public interest litigation, the petitioners have alleged that the collector Kotak has in an illegal manner is usurping the property of the Baravati Palace, which is situated within the stadium campus, i.e. Baravati Stadium, an international stadium and sports complex. According to the petitioner court, the aforesaid property is managed and is under possession of the Olympic Association, unquote. The said property is now being used for the activities other than the sports activities. So, the petitioners has also alleged that the collector Kotak, for purpose of Mission Shakti, has been developing a market complex in this said space. So, in order to buttress their claim, reference has been made to Krishanlal Gera versus State of Haryana and others, 2011-10 SSC, 5-9, where the apex court had in a completely different context had occasion to observe, having referred to the Parliamentary Standing Committee's report on human resources development, that the Parliamentary Standing Committee emphasized on optimal utilization of our existing sports infrastructure. Stop. It has been also observed that some of the huge stadia and other sporting infrastructure in the metros are being utilized for different purpose, not relating to the sporting activities. In para 26 of the said report, it has been further observed that a sports complex cannot be converted into a recreation club. Recreational clubs usually have provisions for recreation with swimming pool, tennis, badminton, table tennis, within the indoor and outdoor sports, restaurant with bar and the lounges and areas for gathering, interaction and function. Merely because a recreation club has provision for some sports activities like badminton or tennis, it doesn't become a sport club, nor can a sports stadium belonging to the government with special infrastructures created for sports. Athletes and sports persons can be converted into there is a problem. For sports, athletes and sports persons can be converted into recreation clubs, nor can a stadium complex be used for non-sporting recreation activities or for holding marriages and other functions unless it has been planned in a manner providing for a recreation club. On that basis, Mr. Nandal and a senior counsel has stated that this is a space relating to the Barbati Stadium, which can be utilized for the sporting activities only. If other activities are permitting, that would affect the stadium stuff. Mr. Nanda has fairly submitted that earlier the Olympic Association of India was unlawfully, Orissa Olympic Association was unlawfully running a Kalyan Mandap in that place. Stop.
Just one line subject to your lordships. From 2020, they have said that there is absolutely nothing which is being held there.
Ah, yes.
Yes, that is.
That
Probably because of that period, there are no parking facilities.
Is there. So Honorable High Court has also imposed some restriction for which 2020 it is discontinued.
But it's lying unused.
However, the said space was lying unused since 2022. February 2020. So it has been admitted by Mr. Nandal and its counsel that the Orissa Olympic Association constructed 23 shops outside the stadium.
Near this Maroon Palace, just adjoining this Maroon.
it's on the crowd itself at different places, but only
near the bar.
As well as this on government road.
Already the 29 shops.
23
shops. And, on the adjoining boundary of these present land under reference. Stop. Mr. Nanda has drawn our attention to a decision of the apex court involving this present space. It starts from which page?
Which one?
It starts from page 24.
No.
The judgment starts from page 24.
24 to 105.
Right. The Orissa Olympic Association, General Secretary, Appellant versus State of Orissa and another. Judgment dated 109, you say?
109, it ends.
The date will be available on the
Yes.
day. Dated 11/9/2020. In
April.
civil appeal number 6450 of
April
2016.
3, I think. 3rd April 2017.
First is 3rd April 2017.
17, page
That
one.
is subsequent, which was the report was accepted your license of page. All right, that is September 11, 2020.
3rd April, where is the date is complete?
Last page.
104 in the brief, which is page 81 of the judgment.
All right, 3rd April 2017 and subsequent order dated
11/2020.
all right. In the order dated 2020, the apex court has clearly observed as follows, para 55 at page 101. In view of the foregoing analysis, we arrive at the conclusion that the suit length from higher upon 23 shops have been constructed and rented out belongs to the state government, that a part of the Kalyan Mandap is built on the government land and a portion of it on the leasehold area of the association, semicolon, and that the association could not have constructed the quote-unquote Kalyan Mandap in this manner, and therefore a portion of the land deserves to be resumed by the state government. That the arrangement entered into by the association with Messrs. M/Income Associate is absolutely illegal, and there is a conflict of interest since the secretary's son and son-in-law have been inducted as partners in the concerned farm, semicolon. That there is revenue loss, as the audit report of the accountant general is appreciated, semicolon, that the secretary of the association could not have been instrumental in unauthorized construction on the government land and in generating revenue therefrom, semicolon, and that there is a serious concern about the nature of revenue generation, utilization, and the loss sustained, and that the whole thing makes us feel that there is something rotten in the management of the affairs in fiscal aspects. Thereafter, unquote, thereafter the apex court has concluded the issues as raised in that case relating to the same space as follows. Quote, 1. The collector Kotak, page 102, shall take over possession of 23 shops and the Kalyan Mandap. 2. The Department of Revenue shall be entitled to continue the tenancy and maintain the Kalyan Mandap and manage the affairs of the said property through District Collector Kotak. 3. No tenant or anyone shall be entitled to institute any litigation in any manner in respect of the said property involved in this appeal that has arisen from TS number 312 of 1991, instituted in the Court of Additional Civil Judge, Senior Division, Kotak. 4. I make it underline. The government, if it decides to manage the property by entering into the fresh agreement, is it liberty to do so. 5. The agreement between the association and the Messrs. Incon Associate is declared null and void. As the conflict 6, as the conflict of interest is obvious, and the secretary who is accountable to the public has failed to conduct himself as required under law, is debarred from contesting from the post of the association. Stop. In the present litigation, the petitioner has demanded that the space where the Kalyan Mandap was constructed earlier cannot be utilized for any other purpose other than sporting purposes. Sporting activities stopped. Number, Palestinian Council has submitted that since the stadium is adjoining to the space, it will be better utilized if this is utilized for sporting activities. Stop. To Mr. D.K. Mohanty, the collector got off as by the counter affidavit. In the same affidavit, it has been clearly stated that after the sale judgment of the ethics court, the collector has taken over the position of the sale space, including the shops. Stop. It has been also asserted that the resumption of the said area by the state government was allowed by the Honorable Apex Court, and they are now at liberty to utilize the said space for any other purpose other than the sport activities. As it is evident from the state decision of the Honorable Apex Court, that for commercial purpose also, the said space can be utilized. Stop. Mr. Nanda has submitted that the purpose for which this space would be utilized by the collector quarter is to creating is a commercial space for the small entrepreneurs under Mission Shakti. In this regard, in the affidavit, it has been clearly stated by the collector quarter that the Mission Shakti aims to empower women across the state. It is of paramount importance to establish an ecosystem for strengthening the livelihood initiative through creation of a robust marketing and distribution network, a platform where the self-help groups within bracket SHG, close the bracket, are able to sell their produce and generate a healthy source of income. With the above objective, the state government planned to set up Mission Shakti Bazar at commercially viable location or promising tourist places of the district with high footfall of the consumers / tourists of each district. This will facilitate marketing of the SSG products ranging from the best of the handicrafts, handloom, food items, organic products, spices, etc. from the Mission Shakti HSG of the district and nearby district. Stop. We do not find that the petitioners can have anything to say. Can have anything to say about the policy of the government to utilize a land which has been directed to be taken over by the government also for the commercial purpose. That apart, as we looked into the history of the utilization of this land, it showed it was never exclusively utilized for the sporting activities. Stop. In para 15 of the said counter affidavit, the collector Kotak has also emphasized as follows, para 15, that it may be stated here that the objective behind it, is not to earn revenue, but to ensure empowerment to women, SHGs of the district, and to market their products throughout the year, which will otherwise develop their livelihood. Stop. We, having noted that this space is not part of the Barbati Stadium, and it doesn't have any history of being utilized for the sporting activities, And
In
also,
fact, it was utilized prior to the constructions of the Kalyan Mandap because my lord, I think Justice Rath had the personal experience of going there also.
yes.
But 99,
Yes.
Since 1999.
19.
Since 1999, we do not find the concern of the petitioners has any importance, or that the purpose for which the collector Cuttack district is using this plot it can be diverted for purposes of sporting activities. As such, we do not find any merit in the public interest litigation, and the same stands dismissed. Huh? That the space shall be utilized in such a manner that should not create any disruption in the traffic flow or the movement of the pedestrians on the road outside the space.
Okay. Deeply.
No. Outside the. No, I said outside the roads will not be disturbed. There is a road going to the stadium.
Yes, my lord. The entire both sides of it, inside the sporting.
Entries. My lord knows there are 5 entries to the stadium.
Already, the collector got to take sufficient care and caution so that the road leading to the stadium throughout that space are not any way obstructed
Deeply obliged.
during the sporting activities that may take place in the stadium, not on other days.
Not another, obviously, my lord.
Sporting activities,
Item 16, only 1 minute.
close it. They may close it.
Because I have difficulty after that, only 1 minute time. 16. The substitution is to file the sole after the respondent has died.
Okay.
So that was kindly grant 1 week time. My lord, kindly see the last order on 6/2/2023, my lord. That is, who could not be able to file, that is why I am.
Already give them another chance to
Man.
file it because someone has expired.
Let them give the copy of the objection to the applicant.
At the request of Mr. P.K. Mohanty, Learned Senior Counsel, appeal to the appellant, let the matter be listed on 31st of August 2023. Meanwhile, the appellant shall ensure substitution of the sole respondents in this appeal.
Not sole, but one, respondent one.
Only sole, not sole respondent is,
Ombudsman is the another party.
okay, respondent number 1. So in the event of failure to take such steps, we will be compelled to pass an order for non-prosecution.
Daily fixed date, my lord. 31st.
31st is more than 20 days, almost.
Bad. Let's next item 17. Mr. Sahu is on accommodation, I pray for next week. Item 17, next time.
Item 17.
17.
You are appealing to the petitioner?
My lord, madam. On behalf of Mr. Sahu, he is on accommodation, lordship.
What is his good name?
P.K. Samantrai.
At the request of Mr. P.K. Samantral and counsel appearing on instruction of Mr. N.K. Sahu, let the matter be listed on 8th of September. No, sorry, no. It will be on the 12th of September 2023.
Yes, ma'am. Grateful, lordship.
So who is appearing for the government? Mr. Khuntia is there. Mr. Khuntia or Mr. Behera?
Lordship.
Item 17.
17, I am there.
Mr. D.K. Mohanty.
17, I am there.
Additional government advocate appears for the opposite parties number all. Opposite parties number no. Opposite party number 1, 2, 3, and 4. The rest of the matters will be taken up at 2.
17 February. September.
Notice matter. Is the contact.
Where is this? File? It is not on. All right, in the physical file. For this matter.
Matter listed for on special notice. WPC 3487/2021 with WPC 4753 of 2019.
Your Lordship, I'm sorry, I'm appearing through BC, Your Lordship.
Yes.
Your Lordship, a date may be fixed, Your Lordship, in the meantime.
Again a date.
Yes.
Your Lordship, actually, in fact, I was ready in this matter, but unfortunately, I'm suffering since last 10 days in dengue, Your Lordship, and my entire family.
Oh, okay.
Your Lordship,
That's.
I'm also appearing.
I am for ILFS, my lord, with Mr. Panda.
Yes, Mr. Singh.
My lord.
So, Mr. Mishra is suffering from dengue.
Yes, my lord, I was informed so.
So that another date you propose?
Yes,
Can it be on 16th?
My lords, I'm a little difficulty till 25th because I have a teaching assignment, my lords. That is my only difficulty. If I could be given 25th August.
All right, 25th of August. All right. Mr. Mishra, I think it is okay for you.
Yes, hopefully my friend will recover.
It will be at 2 p.m. and 25th of August.
I'm entirely. My best wishes to my friend.
No, first half is the only single day.
But 25th is a Friday. Your lordships have that arbitration.
No, this nowadays I only did the first part of this day. I hold the arbitration cases. Otherwise, I can do one thing. It will come in the first half because usually the arbitration cases I take in the second half. As I was planning to change. If you want in the first half, that can be taken on the first half also.
My lords are asking me, my lords.
25th, this before lunch. Hello?
I think my friends are more comfortable with second half.
Not comfortable.
More comfortable. I think.
Okay, that I will change. On that day, I will change it.
I'm entirely grateful, man. Entirely grateful. I'll be there at 2 p.m. on 25th.
At 2 p.m. After that,
this may be put in the list, my lords, because
that was a problem because it was the half. All right, it will be on list. Just take care that it comes on 25th. Okay.
And I am also appearing the second case. There are two cases.
Yes, Mr. Chimankar. What is the notice? Notice. The first is Mr.
Singh.
No, Mr. Chilana is not here. Who is appearing for the petition?
I'll inform him, my lords. I undertake to inform him.
No, all right. But today, who is representing? Abhishek is there? Abhishek Mohanty? No, okay. All right. In first,
my lord, cast that obligation on me.
All right, Mr. Singh. I am writing that you have appeared on instruction of Mr. Chilana.
Malus may not say that. I may not have instructions, but I can tell him that.
Okay. Okay, none appears with the petitioner. As the matter has come in the special list. No, none appears with the petitioner. They appears with the petitioner. This matter has been listed today in the special list. Mr. Chimankar and Haris Chimankar and Senior Standing Council, Commercial Tax.
Central GST. Mr.
Central GST. Central GST. And also CT, I think.
No, Your Lordship. I'm on behalf of CT and GST.
Oh, all right. And Mr. Sunil Mishra. When council appears for the CT and GST. In the other case, Mr. Harminder Singh. Council appears for the petitioner. And Mr. Mishra, you are also there, I think, next case.
Your Lordship.
And Mr. Radhishan Chimankar. So both the common order is there, no? As agreed by the council for the parties, that the matter be listed again on 25th of August 2023 at 2 p.m. for a short hearing on the point as identified in the order. First order was
Notice the Honorable Chief Justice had a query regarding the composite supply and the scope of Section 8. if I'm not wrong.
that is the only issue, Section 8 of the Orissa
Yes, yes.
GST Act, nothing is there. They have to define, because only problem that I was finding,
My lord, yes.
the advertisement, notice inviting tender, this nomenclature of the description of the work is something different. That is why I needed your explanation.
My lord, yes. I'll do that, give that explanation to my lords. Insofar as the scope of Section 8 is concerned. In fact,
Order dated 6/7/2023. Right.
the scope, my lords, is entirely covered in my own case, which I will read out to my lords, and also reference that with the present contract.
No, your approach, we have understood that you are giving the various literature of the program itself, is supplying to computer education, but problem is that the NIT descriptions is completely without training. The word training is missing. When they
I'll show my lords from the policy and where
the
we
problem is the policy is one thing, Mr. Singh, but when the order, the NIT, supply order,
as also the contractual arrangements, my lords, as also the contract.
that you come, that is this part only you just highlight.
That I will show my lords.
All right.
Certainly. I'm entirely grateful.
Keep it in the file. After scanning, please scan the code. It's called now. Just notice.
Item number 26.
May I please, your lordship?
Yes.
My lords, on the 3rd of March, the lordships were pleased to make an order. In paragraph 2 of that order, your lordships noticed the certificate of delivery of possession, wherein this is, my lords, this is the order passed on 3rd of March.
Yes. Which part that you want?
Sir, paragraph 2, the last part of paragraph 2, your lordships took note of the certificate of delivery of possession, and there your lordship sees the description of property, which shows that on the north there is a 200 feet road, and east there is a 30 feet road. And the allegation was the access to the 200 feet road has been taken away. That is the writ petition, my lords. Now your lordship sees in paragraph 6, your lordship issued certain directions to form a committee. May I place paragraph 6?
Yes.
In the circumstances, we propose a committee of the technical persons to be formed, and such committee shall be formed by 3 technical persons selected by the major stakeholders, that is General Administration Department, Government of Orissa, Bhubaneswar Development Authority, the Revenue and Disaster Management Department. Each of those departments would select one technical person adept at surveying the land and holding a position to suggest the alternatives in the report, how the adjustment can be made, keeping 1, the advantage that was granted to the petitioner intact or minimally adjusted, and 2, how the petitioner's access the 200 feet wide road can be maintained. We also direct the proposed committee to support their alternatives or suggestions by maps so that it can be easily understandable by all parties who are involved in the controversy or who have stakes or interest. We direct the General Administration Department to coordinate in forming the committee. Such committee shall be formed by the 17th of March 23 by publishing a memorandum. The survey shall be completed by the 4th of April and the report be placed to this court on the 11th of April through Shri D. Nayak, Learned Additional Government Advocate. We would request Mr. Nayak, Learned Additional Government Advocate, to supply copies of the report and maps and whatever other enclosures that might be attached to the said report to the councils representing the petitioners and the opposite parties. Now, the report was, before the report could be filed, I filed, my lords, as opposite party on behalf of opposite party number 7, who has been made leased out this particular land. I have filed IA number 4827 of 23. 4827.
Yes.
Of 23. Your Lordship may kindly take up that application.
Yes.
I seek for recalling this order dated 3 on the premises which are stated in the application. The premises, my lords, have been set forth from the first paragraph onwards.
No, after reading of your application, what has traveled through my mind is that you are saying that there is no access from the petitioner's plot to this 200 feet.
Absolutely right, my lords. There is no access. There was never any access. And they have, in fact, all residential, these are all residential plots. The residential plots can never be granted an access onto the main thoroughfare. They have always been granted access to the ancillary roads which arterial road which join the main thoroughfare. That is the rule in all urban planning matters. And in this case also, if your lordships will closely look at the building plan of the petitioner.
Just a minute, Mr. Mukherjee, hold for some time. Who is appealing to the state? He asked for a report. What happened to that report?
What is that?
Your lordships had called for that report, but once this application came on board, your lordships restrained them from providing copies to us and said that your lordships will take up this application first.
No, that is true. But let us see at the report, because this is your claim. There is no.
Respect for it. I am the petitioner here. If you also looks at the order dated 3/3/23.
That is what has been done out.
The entire order, if you permit me to read the entire order.
No, we have seen.
He has participated at the time when the matter was taken up for hearing. He has participated himself. Change of counsel not give rise to another application to file, recall the application. Mr. Somebody else was.
Because no, Mr. that can be seen from a different angle.
Well,
if this court has recorded something really doesn't exist.
It exists, but if you also looks at Annexure 1,
I'm asking for now the report.
Annexure 1, 2, 3, if you also looks at, the question is at the time when it was allotted, in 2010, Malad, can you appreciate, Malad? At that time, it was road in existence that was earmarked at the northern side. Well, that
existence of 200
exactly
is not in question. What Mr. Mukherjee precisely submits is that there was no connectivity with that road from your plot.
No, sir. Sir, it is directly connected.
Examine. You have not come to a conclusion.
The building plan that was sanctioned and approved itself shows the connecting road.
No.
The building plan is approved.
It doesn't show it.
Well, let us examine the records. By which affidavit you have filed the report, Mr. Muduli?
What they have done, the change of, after the settlement operation, they have carved out this 200, shifted to another 200. There is a gap in between my residential house and so far as the road is concerned. They have shifted the road saying that this is surplus land and BDA has surrendered it in favor of the government and leaves out in favor of them. There are two very important aspects are there. This is a residential zone. As per the CTP plan, no commercial activities can be taken there. Commercial in the sense, hospitals are prohibited. They have given it to the hospital. But these are aspects you are supposed to see at the time when the matter will be taken up for hearing.
But I am just today accepting.
Exactly. Then you must see the report.
Let us see the report. That is much reliable document because all the parties have been given the opportunity of.
So, sir, copy on us and you must see it.
No, let us.
I think Mr. Muduli, you can take help of Mr. Naik has suddenly come to this court. He is aware of this matter. Mr. Devashish Naik. I think Mr. Muduli will be immensely benefited if you assist him finding out that matter that he asked from the government a report after survey regarding connectivity to the 200 feet wide road.
General administration.
Right. Whether the report.
The report is there, the original is not here.
It's all right. That original might.
Have you filed it?
Something.
Filed it.
Original is probably here.
They should file with a copy to both sides.
I think they should file it first.
Copy has been sought by Mr. That report was, my lord, served because the petitioner remembered to came to object to no. Somebody else appearing. And in fact, they have time to object to that report. Yes, sir, not filed report.
I don't think there is an.
It has not been filed, sir. It has not been filed. It has not been filed.
But it should be filed with copies to all the Afghans.
Yes. Thereafter might.
So I'm fixing the matter again on sometime in.
My anxiety is that OPD is to be situated on this land.
No, we understand that.
So that is my anxiety.
It's a prohibited area. You cannot have a hospital there.
That is why ultimately on the report, the objections and everything will invite. It is complete. Let the matter be finally disposed of.
Yes, that's what I'm saying. The matter is finally disposed of.
Mr. Muduli, you file in short everything in the report.
Enclosing that report.
Within how much time you can file it?
No, within a week.
Within a week.
Enclose that and
A copy to us.
Obviously, copy has to be given, and we'll today itself the order will reflect the objection if any can be filed.
Yes,
by such and such date. So you filed by 18th of August, it's February, but that the matter will not be listed. We'll list the matter on 28th of August. In the meanwhile, the who are interested to file the objection, they may file the objection.
Right.
And on that day, we'll decide a date for hearing. Right. In terms of our order, we will record the names of the council who are appearing for them. Dated 3rd of March. No report has been filed by the committee, as directed to be constituted by the General Administration Department, Government of Orissa. Though we had directed to form the committee by 17th March 2023 by publishing a memorandum. So the survey shall be completed by the said committee by 4th April 2023. And the report be placed to this court by 11th April 2023. Stop. Mr. P.K. Muduli, learned additional government advocate appearing for the state opposite parties, has stated that the report has been sent, but inadvertently.
No, Manoj, may I just interject, Manoj? In fact, the report, they were ready to file the report. But since my application was on board, your lordship restrained them from filing the report.
Where is that order?
That order, I don't know whether it's reflected in the order. Lordship had
last day, as you can see.
That in the court.
2023.
The report was ready on that date when the matter was on board.
No, you requested this court not to consider that report.
I did consider, and that is the reason why your lordship asked them not to serve copies and not to file it. That may not have been reflected in the order, but this was what was verbally given out by your lordships in the court on that date.
But Mr. Naik's submission has been recorded. He says the report has been filed.
No, it has not been filed.
It's not been filed then.
He also says that maybe it is in a sealed envelope. Maybe-
Originals are not there.
It must be a sealed cover thing.
But the report has not been submitted before this court by an affidavit.
पिछले सब पक्षरे कोण अछि कि एनवेलप के कोण
Report is there.
Report is accompanied by a colored map.
But let's see, then that is why actually, yes. Just scroll down. Mr. PQ Middle and
noting has not been done by the court master.
The report was submitted, just this part of the episode. The report has been submitted before this court directly by the Joint Director of Estimates, Additional Secretary to the Government, by forwarding letter dated 6/4/2023. Stop. After filing of the report, the opposite party number 7 has filed the you 4827?
Yes, but it was before filing of the report. I had filed this on the 3rd of April.
It is
before the report was.
The report was filed on 6/4.
I had filed this on 3rd of April.
All right. It appears from the records that before filing of the report, opposite party number 7 has filed an interlocutory application seeking modification of the order dated 3/3/2023 to the extent that the petitioner's plot from the northern side, there exists an access to the petitioner's plot from the northern side, and hence the said order is required to be recalled or modified. Is it correct? This is the thing, you have done it. That you said that there exists an access to the petitioner's plot from the northern side is and hence required to be modified or recalled. That is your paper.
That access is from the 30 feet wide road and not from the 200 feet wide road.
So kindly just 1 second, Bharat.
These are not coming to any interference.
Document being filed, I will be asking.
Firstly, under senior counsel, appearing to the opposite party number 7 is submitted that petitioner did not have any connectivity with the 200 feet wide road. Be that as it may, that since the report has been submitted before this court, will direct the registry to serve the forwarding letter dated 6/4/2023 along with the memorandum dated 15/3/2023 and the report of the state committee, which was signed on 4/4/2023 to the council appearing for the parties by 18th of August 2023. The petitioner and other opposite parties, including the opposite party number 7, will be if into the opposite may file any objection against the said report if they are so inclined by 27th of August, by 25th of August 2023.
25th, madam.
Let the matter be listed on 28th of August 2023.
Pardon, my lord, a copy of IMA be solved upon us. Copy of IA may be shorter. Copy of the IA, my lord. IA may be section. Interim application. That's not shorter.
Not served.
Yes,
Mr. Mukherjee, tell you one of your associates to serve the copy.
I'll do that. I'll have it.
Collect in the course of the day.
Your lordship has fixed it to 28th of August. It's at 2 p.m.
Already at 2 p.m. 28 at 2 p.m.
Already 2 PM.
No, I was little that report was not filed because report was directly filed. That is why we are searching in the affidavit and that is not scanned. Tell them to scan the report also, under report only.
Scanned heading may not have been there.
No, there's no mention of the reports. They
Keeping it like
ask
that.
use the word report.
Another matter fixed for 2 p.m.
Call out.
Matter fixed for 2 p.m. Item number 60.
So that interim model is there, it will continue.
Interim model, of course. Interim model.
May I please lordship?
Oh, okay.
Now, this order of the central institutional Kotak bench is under challenge. He is at Annexure 1. Now, in this case, my lord, the state has filed counter and I have filed my rejoinder.
Yes.
Whereas the UPSC also,
the state.
Yes, UPSC also has filed counter, but I have not filed rejoinder on the ground that they have simply repeated what they have filed in the CAT, in the central court. So I did not prefer to, I will only adopt my counter there and also my interpretation here. DOPT have not filed counter there, so they have not filed anything here.
Just learned counsel, just before you enter into the submission, whether Union of India has filed the counter?
No, not even there in the CAT.
One has not filed.
In both the forums.
Who has filed? No.
Who has filed? UPSC is the main contender who has.
Understand.
It has filed counter in the CAT on the Constitutional Tribunal, and here also filed the counter.
And what about opposite party number 3, Government of India?
Government of Orissa.
Government of Orissa
has filed the counter. I have filed the rejoinder there too.
I have also received an in course of the day. File a reply to their rejoinder. So
reply to rejoinder, it will only elongate my. That is the reason precisely my concern.
And what about the 4, 5, 6 and 6, 7, 8?
4, 5 private respondents copy has been served by the state. That is my order dated 17/1/2023. I can listen. There the government advocate has said that already you served the copy on 4/22 for the office of Chief Secretary.
To 24. They have not filed anything before.
No, madam.
All right. It is not recorded. They have filed before the tribunal.
4/22, my lord.
No, before the administrative tribunal, they have filed.
My lord.
Whether they have filed before the administrative tribunal?
No.
Okay. State of Orissa filed?
Yes.
except us, everybody is filed.
You have not also filed before the tribunal.
Yes.
Mr. Haq is in BC. He is his counsel is in BC matter.
All right.
Madam, for respondent to UPSC, I have
All right.
filed the counter of
Okay. Anyone is there? Any counsel is there on the did not? Only Mr. Hawk.
Yes, Mr. Haq. Yes. My lord.
Okay. So, Mr. Frontier, is it really necessary?
I got that instruction. If your lordship will permit me, that I can file it by Monday. But that already I have got. That is also with me that I have corrected it and will file it by tomorrow. If your lordship grant me 2-3 days time, that I can file it by Monday, so that your lordship
No, file it by Friday, tomorrow. Can it be done?
Yes. It's filed by.
Supply copy to him on tomorrow itself. We will take up the matter on Monday.
Monday, will reply to the vendor, I have not had a.
If you bring the fresh,
No, nothing, no, new, nothing. They have rather, but a new document.
no, that is why. What is your right to file an affidavit then? Recent materials are not brought in the rejoinder.
Some materials haven't brought in the rejoinder, so I had.
What?
Certain documents that regarding that punishment and the communication of that order, why that has.
All right, I am telling you very clearly. It can be this established that no new material was disclosed in the rejoinder, the additional counter affidavit will not be accepted by the court. All right. At the request of Mr. M.K. Kuntial and additional government advocate, appearing for the respondent number 3, the matter will be listed on Monday next. Mr. Kuntial and the counsel has stated that he has been instructed to file additional affidavit in response to the rejoinder that has been filed by the petitioner. Such affidavit shall be filed by tomorrow. After applying the copy to the counsel for the appearing for the particular and the counsel for the respondent number 2, only to Mr. Rock and so it is made absolutely clear that the additional affidavit will only be taken into consideration if it is found that in the rejoinder, found that has been filed in response to the new facts or documents brought by of the rejoinder. So Mr. K.C. Kanandul and counsel has submitted that matter requires early disposal, and that is the reason why this matter has been listed today on special mention. So, the matter to Monday.
My lord was pleased to fix the matter on 3 occasions at 2 p.m.
No, that doesn't give you any right.
No, what I humble
fixing on Monday at 2 p.m.
Yes. And
Mr. P.K. Pari, Deputy Solicitor General of India, has appeared for Union of India. All right.
Sometimes it doesn't reflect the time. That's the whole problem. I have to come.
It's a mistake. Actually, just tell them to reflect the 2 p.m. There is no representation for the response 4 to 22. The serious.
My lord, I am for respondent number 2, my lord.
I have reflected your name. Mr. Hawk's name will be too. Just Kumar.
Yeah.
It will be reflected your name. Don't worry.
Item number 15.
Challenge to the virus of section 14(1)(h of the
earlier occasion you told that you will file a rejoinder.
I'm actually withdrawing it because there is no regulation as in date. I'm seeking leave that only when it make applicable.
Exactly. We just simply don't understand this thing. Mr. Rath, GM Rath, counsel, appearing for the petitioner, has submitted that he has instructions to withdraw the petition. In respect thereof, he has filed one memorandum of withdrawal seeking leave of this court. They do not find any impediment extending that leave, and accordingly this petition stands dismissed as withdrawn. Memorandum that has been filed in the proceeding today is taken on record.
Item number 19.
Item 19, you have seen there is an IA for an early date of GAV. That they are filed for
for the respondent, I have filed
I have for early date of hearing, Lordship.
Lordship, this for the fixing it. Any day.
Wait for it.
Where was which date? In the next month?
Your Lordship, I fix any date. I have not taken.
Next week, any date, Lordship.
Next week is not possible. Board is seriously congested. I'm
As Lordship, meanwhile, Lordship, other petitioner, other private cell employee, Lordship, going to regularize. If they regularize, Lordship, the petitioner may be hampered, Lordship, because there is no any regular post has been available, Lordship.
No, we are fixing on 13th or 14th September.
Lordship, earlier it has fixed for 11th September, Lordship.
11th September.
Lordship.
Want to prepone it.
Lordship.
So they make it on 5th of September. Because this month, the matter will be listed, I'm sure that will not be taken.
5th September, many matters are.
Also 5th.
Your Lordship may fix either.
Replace matters.
That's what matters.
What is the date? Closer date, just check up. Can be 14th also can be matters.
11:42. 8, 9 matters. First.
May I take your Lordship? Fix it to 31st August.
Oh.
31st August?
That is good.
59.
No, all right, 31st August.
59 matters.
All right, 31st of August.
Reflect the name of escape opposite pattern number 25 and 26. Reflect the name 25 and 26.
I'm not getting you. Come closer to the microphone.
I don't know. Escape 25 to 26. Respondent 25, 26.
You are Mr. S.K. Purohit?
On behalf.
On behalf.
Already reflected, Lordship. In cost title already reflected.
What is it?
Cause listers. This is reflected in cause listers.
It is appearing for university.
Who? So this is the whole thing, the agenda something like that. It is a state appeal.
Yes, state appeal.
And you are appealing for whom?
For the invoice.
Who filed this?
Respondent 25th, Lordship.
No. Who is filed it?
State.
Appeal is by state, item 19.
Who filed this miscellaneous application?
I am for us filed by respondents.
For what?
I am for the respondent number 14, Lordship. He is appearing for the university respondent number 25th and 6th, Lordship.
You are appealing for the university.
My lord.
And you are appealing for whom?
I am for the respondent private employee, Lordship.
Private respondent.
Private respondent. Except 25 and 26, except all respondents.
Nothing there in the petition. Whose petition is it?
Respondent number 1 to 24, Lordship.
I filed for no.
I know.
Say that
Yes, Lordship.
Well, just from the petition you show who filed this application.
We have
From the petition you show that who filed this application.
We have filed.
You are saying from the petition, it is a judicial record.
No, Lordship. Respondent, Lordship.
Where have you written?
In the interlocutory application, who is filed?
Respondent number 14, Lordship.
Where is that?
In affidavit, Lordship.
We have to see the
Affidavit, I am going to from that.
Lordship.
so there. This is the place where it is to be written in the affidavit that I am the respondent number 14. You not write in this body of the cost title. Then what is the cost title means?
Lordship.
This is an application for early hearing filed by the respondent number 14. So the matter is already fixed for hearing on 11th September 2023. So, as agreed by the council for the parties, let the matter be listed on 31st of August 2023 at 2 p.m. for hearing Stop. Mr. M.K. Kunti, or an additional government advocate, has appeared for the state appellant. Stop. His name also reflects on the 14. All right.
Item number 20.
Yes, Mr. Visual.
Please, Your Lordship. I prepared a very brief date chart, Your Lordship, list of dates. The present appellant, my Lordship, he was working as sub-inspector of police in the 1998 to the start the vigilance case. Subsequently, on the basis of the charge sheet filed in the case, a disciplinary proceeding was also issued against him, Your Lordship. Now, in 2011, he was found guilty in that vigilance case, and according to that judgment, he was dismissed from the service. Subsequently, he challenged that order of punishment before this Honorable High Court. This Honorable Court held that he acquitted him, Your Lordship. Now, subsequently, he was reinstated in service. Now, when he was reinstated, Your Lordship, the disciplinary proceeding, which was pending for 2004, was again reopened. Now, after that, my Lordship, the inquiry was held. I should kindly see the inquiry report. It is at page number 48, Your Lordship. Is the finding of the inquiry officer, Your Lordship. The conclusion is at page number 62. I'm reading it slowly, Your Lordship.
Is
thus strictly limiting to the evidence and documents brought on record in this disciplinary proceeding, which have been discussed and summarized above vividly, it can be reasonably deducted that the calculation of the DA, which forms the basis of the charge against the charged officer in the disciplinary proceeding, suffers from serious flaws and infirmities, and hence not maintainable and sustainable. The established principles of disciplinary proceeding, which is quasi-judicial in nature, require that the charges should be framed in a clear, precise, and flawless manner. Since the disciplinary proceeding stands on erroneous and inconsistent calculation of DA against the charged officer, which has already been rejected and set aside by the Honorable High Court, it will be against the spirit of law and also the principle of natural justice to hold the charged officer guilty of the charges. The facts on record no way substantiate the charges leveled against the charged officer conclusively and beyond reasonable doubt. Further, the submissions made by the charged officer in self-defense in this proceeding inquiry have no way disputed, contested, denied, refuted by anybody by any means of reasonable and rational evidence, arguments, or reasoning. Further given, ultimately, he found that the petitioner is not guilty, Your Lordship. Now, Your Lordship, may kindly see the memorandum of charge. It's at Annexure 1, page number 22, Your Lordship.
Where we can get the final conclusion at which page?
That is at, my Lordship, page number 62. It starts with the heading conclusion. The last portion is, hence the charged officer Shri Ashok Kumar Sahu, Sub-Inspector of Police, is found not guilty of the charges leveled against him in this proceeding inquiry.
All right.
Yes, Your Lordship. Now the charges were, Your Lordship, at page number 23. I don't know if it's legible in copy or not. It's not legible in my copy, Your Lordship. Page number 22. On this basis, the disciplinary proceeding was initiated.
At page, you are referring to page?
Page number 22, Annexure 1, Your Lordship. The charge.
Yes.
They have completely relied upon the charge sheet filed in the vigilance case, Your Lordship. On that basis, the disciplinary proceeding was initiated. Now, in the memo of evidence, Your Lordship, may kindly see at the next page.
Completely illegible copy. I don't know whether the physical copy is check out whether the physical copy can be read.
In my
with you? Yes, sir. Page 22. The same issue, Mr. Visual, we just try.
Even in my copy also, Your Lordship, it's a
typed copy.
I will file a typed copy, Your Lordship.
We are fixing the matter on 13th of September again.
As a Lordship pleases.
Yes. Is the matter again 13th of September. In the meanwhile, Mr. J. Biswal and counsel into the appellant shall file the legible copy of, this is the annexure?
Annexure 1, your lordship.
Legible copy of the annexure 1. Legible typed copy of the annexure 1. So, today, the Biswal and counsel of the list of dates for and on behalf of the appellant, which is taken on record.
Much obliged.
Who is appealing for the state? Mr. Amkit Kumar has appealed for this. Yes.
Item 21.
21, my lord, I do not have any instruction further in the matter, my lord. Therefore, I do not press it.
All right. Natural Kumaran and counsel appealing to the petitioner, they submitted the real instruction. In view of their statement, if the dismissed for non-prosecution. Mr. Mahathir, are you appearing?
Yes, my lord, I am.
Mr. B. K. Mahathir, additional government advocate.
Yeah, matter.
Rehabilitating for the no families. Appealing for the opposite parties number 1, 2, 3, 4, 1, 2, and 3. Stop. Therefore, prosecution or harm. The petitioners will have liberty to approach this court again if their givens continues even after this order.
Item number 22.
Yes.
May I please?
In this case, lordship, the petitioner challenged the Rule 20 of array scheme lordship, process array Rule 2020 lordship. And similar case lordship is also dispatch.
Recently taken a view on this Rule 6(9) of the Rehabilitation Assistance Rules 2020.
Yes.
Whether the new rules will apply in respect of application.
All these matters, I think it is fixed on 18th. This matters. 18th or 17th, I don't know.
What lordship, in similar case lordship, WPC number 2081 of 2021 lordship, lordship of disposal.
No, these other matters have been fixed very recently, 18th of August perhaps. I just fixed it on 18th of August. List on 18th. Just you ask this Jyoti, give the date confirm. It is either 17 or 18. Check up the order, huh?
Let's see. Please.
18th. Mr. Honor Bearer. Mr. Pradhan is for the petitioner and Mr. Honor Bearer for the state respondents. All of the parties. All is on 18th is
Item number 23. My lord, the matter is infructuous.
Good job.
Appellant is dead.
Dead. So it is abated. You are Mr. Pradhan.
Asutosh Mohanty. On behalf of Mr. Manoj Kumar Mohanty.
Mr. D. Mohanty and counsel again instruction of Mr. M.K. Mohanty and counsel for the appellant has submitted that the sole appellant has passed away and as the appeal is related, passed away and nobody has come forward to continue the challenge. Hence, the appeal stands abated. Accordingly, the appeal is disposed of on abatement. You're there, Mr. Kuntia? Mr. Behra, Anna Behra, for the opposite parties. Next.
Item 24. 24.
Another senior is on line. I mean, person petitioning this case. Learned senior is on line, madam.
File the status report with regard to a particular case now in Chandipur PS case on 7th August. Your Lordship may kindly.
May I pray for password, madam? Because just now I sent the copy, I received the copy. Just now I sent the copy to my learned senior.
You have received the copy today?
Ajit Pajapam Dilaji.
No.
Ajit Pajapam. Just for report.
Then it can be taken up any other date because I have filed the status report. Time to time, your Lordship is asking for status report. That your Lordship may kindly have a view on that.
Or your Lordship kindly pass over or
pass over.
Your
The matter be listed on 1st of September 2023.
Pardon?
1st of September.
Obliged.
Item 25.
Item 25, 19875 of 2019, that's a hard impact. I'm reading that. That's why I've given it date chart, but I've made it a further development. That will cover all the cases, I think. And my wanted that Mr. Mahanti is appearing, he also can supplement me. But I have very. See, 17875 of 2019, the second matter.
Then you have already completed your submission.
In fact, not only I will recapitulate, I have already prepared a note of submission also, but very short note of submission. So just permit me to recapitulate your memory so that I can make my submissions. The date of events I am placing that. 2007, the letter issued by DG Police, and filling of the vacant post of Assistant Station Officer in Orissa Fire Service by way of promotion as per Rule 660A of the Police Manual. That is Annex 1. On 16/10/2007, a garrison list that is select list was published for promotion to the rank of Assistant Station Officer. In the said garrison list, the name of the petitioners found place are serial number 169, 174, 184, and 195. That is Annex 2. 24/10/2007, an office order was issued by the Director of Fire Service of Orissa giving promotion to 20 number of candidates from the rank of fireman and Harinda to Assistant Station Officer out of the select list stated 16/10/2007. That is Annex 3 at page 30. On 2/9/2010, a letter was issued by the Director of Fire Service and HON'BLE Orissa to the IG of Police personnel seeking clarification as to whether the select list is valid for 3 years or till it is adjusted. 11/11/2010, in response to the letter seeking clarification dated 2/9/2010, the IG of Police personnel Orissa clarified that as per the procedure laid down in PMR 660, in order to be eligible for consideration of promotion to rank of ASI, a constable who have had 7 years of service after the period spent under training are required to pass the written test as required under clause C of PMR 660. And there is nothing mentioned in the PMR about the validity of the select list of the written test. So then goes to 21/10/2010, after 3 years, completion of 3 years, more 107 number of candidates were given promotion to the post of, no, this is 3 years, 21/10. More 107 number of candidates were given promotion to the post of Assistant Station Officer out of the select list dated 16/10/2007, after 3 years of publication of the select list. Then on 10/11/2010, another 18 number of candidates were promoted to the post of Assistant Station Officer out of the select list dated 16/10/2007 by the DG and IG of Police. Then on 19/12/2014, some of the candidates who did not secure 50% of the qualifying mark in the pre-promotional test filed O number 5.6C of 2012 and batch of original application before the learned tribunal, challenging the criteria of fixing 50% of qualifying mark of the written test held in the year 2007. The said original application were dismissed by the learned tribunal with a finding that 50% of qualifying mark for filling of the post of assistant station officer cannot be faulted with. Further, while dealing with the case of the said applicant, the learned tribunal made an observation of paragraph 9 of the order regarding the validity of the select list. That is annexure A/3 at page 17 of the counter. On 21/9/2015, challenging the judgment dated 19/12/2014 passed by the learned tribunal, the applicant in A number 3748 of C of 2014, a batch of cases, before petition during WPC number 16027 of 2015 before this honorable court, and this honorable court upheld the judgment of the learned tribunal with a finding that the petition had not implicated the person who had got promotion out of the select list stated 16/10/2007 as the necessary parties to the case. That is annexure by 9 at page 19 of the counter affidavit. Then 26/2/2015, a letter was issued by the DG of Police for conducting the pre-promotional test again for the rank of the assistant station officer. In serial number 11. Some of the selected candidates, like the petitioners, whose name found place in the select list of the year 2007, filed original application before the learned tribunal with a prayer to quash the letter dated 26/2/2015 and give them promotion out of the select list dated 16/10/2007. The batch of original applications were filed. On 24/6/2015, the learned tribunal quashed the letter dated 26/2/2015 and directed the authority to act upon the select list dated 16/10/2007 to consider promotion of the applicant of the original applicants. Can we see annexure B/3 at page 30? On 1/2016, implementing the order, also kind of mark this, implementing the order dated 24/6/2015 passed by the learned tribunal in order number 751C of 2015 and batch of cases, 34 candidates, including the present petitioner, were selected to promotion to the rank of assistant section officer, assistant station officer, and were directed to undergo the ASO course of training for a period of 12 months. On 26/7/2016, the petitioner were declared passed and qualified in the ASO course of training and they completed the training also. In WPC numbers also, some unsuccessful candidates who were not parties in the original application approached the honorable court challenging the order dated 24/6/2015 passed in A number 751 of 2015 and batch without impeding the applicant in the original application. And the person like the present petitioners who have already passed the ASO course of training in terms of the order dated 24/6/2015 passed in A number 751C of 2015. Then on 6/7/2017, this honorable court passed a judgment in WPC number 13566 of 2015 and that directing the state government not to give any promotion from the select list of the year 2007, thereby adversely affecting the petitioner as they have already undergone the ASO course of training and are giving promotion in terms of the order passed by the learned tribunal. One thing I have left out, this order was challenged because in the counter they say this order was challenged before the Honorable Appeals Court and the special petition was dismissed at the stage of admission. This is the entire background. Now I have prepared a note of submission for your lordships. This is my submissions for the entire case. This is practically a review because we could not, because we are not party to the application, we could not have filed a review application. Therefore, we have filed this application to recall that order. So far we are concerned, at least that should not be made applicable to us. That is what our case is. The note of submission filed on behalf of the petitioner.
Yes.
Subsection 3 of Section 26 of the Orissa Fire Service Act 1993 provides that, inverted comma, until rules are made under this section, the rule in force immediately before the appointed day and applicable to the officers and staff of the Fire Service Branch of Orissa shall, as far as they are not inconsistent with the provisions of this Act, continue in force and apply to the members. as there is no cadre rules made in respect of the fireman and havildar at the time of appointment of the petitioner, the procedure laid down in the Rule 660 of Police Manual are being followed. This is advocate position. 660 of Police Manual are being followed for promotion of havildar fireman to the rank of Assistant Station Officer. 2. As per PMR 660, a fireman of the havildar having 7 years experience is eligible for appearing in the written test, and candidate after successfully declared passed in the written examination are considered qualified for promotion to rank of Assistant Station Officer and are sent for training, and thereafter appointment is given to the promotional post. Section 12 of the Police Act confers power in the Inspector General to make rules. As per the said section, prior approval by the state government is mandatory for framing of orders and rules as it shall deem fit related to the organization of the police force. So far as Rule 660 of PMR is concerned, the same is silent about the validity of the select list. Further, the authority, when fixing the 3 years validity of the select list, no prior approval by the state government was obtained. Even though such prior approval is mandatory as per Section 12 of the Police Act 1861. Therefore, the fixation of 3 years validity of the select list is in clear contravention to Section 12 of the Police Act. So far as the present petitioner are concerned, they are directly affected by the impugn order, since they are not arranged as parties in WPC number 13566 of 2015 and batch before this honorable court, passed and qualified in the ASO course of training, in the promotional course, ASO by implementing the order dated 24/6/2015, passed by the Land Tribunal in order number 751C of 2015 and batch. Therefore, in absence of the necessary parties, present petitioner, the order passed by this honorable court is not binding and is a nullity. The honorable division bench did not take into consideration of the fact that the present applicant was selected for promotion and accordingly were sent for training and even successfully completed the training. 7. It is an error of record stating that the Land Tribunal did not give any finding with regard to the validity of the select list, since the Land Tribunal has rightly referred to Rule 660 of the PMR and has come to a conclusion that that 66 will be cover, 660 will cover, and therefore the two is adjusted that select list must give an effect to. The impugn judgment has no observation or finding about the PMR 660, though the competency of the IG of police to fix the validity of the select list of 3 years was argued before the Land Tribunal, and the same was accepted by the Land Tribunal in number 751 of 2015. When 80% were given commission after the so-called expiry of the select list were not paid parties. Even after expiry of 3 years, 18% have been appointed. There is no dispute. State government in the counter-affidavit have admitted to all the contention raised by the present petitioners. When unsuccessful candidate approached the Land Tribunal in number 516 of 2012, and that's with no regard to the validity of the select list. That minimum qualifying marks, they are challenged at the minimum qualifying marks. Nothing about the validity of the select list. The one of the interpreters after dismissal of the WPC number 13566 of 2015 approached the Honorable Office Court by filing the SLP, but such a SLP was dismissed without any speaking order. So the doctrine of merger is not applicable to the present case, and the impugn order is available for review before this Honorable Court. Now the judgment I am citing, I prepared also 3 judgments. The first judgment I am referring to, the 2004-6 SCC page 126, which is very well settled. I need not place that. If a judgment has been passed in absence of the person, those who are adversely affected, they have every right to file an application, a writ application to recall that order, because they are adversely affected by that order. That is the Polasing case 2004-6 SCC page 126. And the next judgment I am citing to follow, which stick it. 2022 yes, in abs 2022 Supreme Court 2550.
You are referring to para 27 and 28?
Yes, sir. Yes, yes, sir. Yes, sir. No, para 27 and 28. Judgment copy. So in absence of a necessary party, the order passed is a nullity and does not have a binding effect. And the other judgment are given to receive that 2004 SCC page 317, Khetravasi Vishwal versus Ajay Kumar Goyal, that is out of this Odisha case. There also the same principle has been decided. And the next judgment is that 2019 SCC page 376, that doctrine of merger will not apply. Doctrine of merger will not apply if SLP dismissed, and such dismissal of SLP is not a bar for review of the judgment. That is 2019.
So this is a repetition of the Kunhaya Ahmed.
Yes, sir. Yes. Now you also kindly come to the so far as my brief.
2000.
Yes, sir. May I take your access to page 33, my promotion, on the basis of the select list. 107 were giving promotion even after the alleged date of validity of the expiry of 3 years. Then 18% were giving promotion, as well as you can find out from the date of events, that admittedly they were giving promotion after the expiry of 3 years. So for the real concern, let me come to page 33. Page 33. Yes, sir, I've given copy. Suppose a copy. Yes, I'm giving copy, all the copies, but I told him to make it box. Give it. I'm giving to us copies of judgment. I'm exclusive. Page 33, what's the copy? Page 33. Of the brief. That is of 21/10/2010. The expiry of that list is, according to them,
it's page 33.
33. There is 33, annexure 6. Yes, sir. Let's get it.
Yes.
This is on 21/10/2010. The Central Selection Board held on 12/10/2010 selected the following fireman, public living fireman, driver, having for promotion to the rank of Assistant Station Officer in Orissa Fire Service. They will be deputed to Orissa Fire Service Training Institute, ASO, for undergoing the ASO course of training by Fire Officer Orissa Cuttack in consultation with the principal of OFSI Bhubaneswar soon after the slot are open in the near future. The result of the final examination of the ASO course of training should be sent to this director for fixation of the inter-C seniority, because he says that after the training course is over, they fix the inter-C seniority in the promotional post. Inter-C seniority in the rank of ASO. On successful completion of training, they shall be allowed to hold the higher post of promotion. Let's come to page. So for a petition is concerned, that is serial number. Yes, 8, 9, 10. Let's come to then page 37. It is the promotion order. Let's come to page 37.
Okay.
This is on 10/11/2010. Director of Health Service, Home Guard, the Central Selection Board held on 8. Yes. The Central Selection Board held on 8/11/2010 selected the following fireman, living fireman, driver, Harinda, for promotion to the rank of Assistant Station Officer in Orissa Fire Service. They will be deputed to Orissa Fire Service Training Institute, Bhubaneswar, for undergoing the ASO course of training by Fire Officer Orissa Cuttack, and on successful completion of training, they shall be allowed to hold higher post and promotion. The result of the final examination of the ASO course of training should be sent to the director for fixation of the inter-seniority in the rank of so-and-so. And these 18 persons, those who already got the promotion and they continue. And then let me kindly come the person those who approached the tribunal that judgment of the tribunal which are page 44, Annex 10. Which are the subject matter of challenge at the instance of some third parties, case will look to that judgment.
Yes, yes.
This original WPC number 13566 of 2015, that was, in fact, this judgment was passed against the judgment of the tribunal. Let me go to take your shift to the judgment of the tribunal. Tribunal judgment is at in the counter that has been enforced in the counter. You also kind of have a glance to that judgment that starts from the counter annexure B by 3. Counter filed by OP number 1 to 5. The judgment of the tribunal was on 24/6/2015.
This page 30.
Yes, page 30 of the counter. One page, I'm sure that my bid David Kelly will assist.
Already.
Page 30 of the counter. Page 30 of the counter.
It's not a judgment, it is a office order dated 24/10/20.
Is it annexure B by 3?
Yes, sir. Yes, madam. 24/6/2015. Right? Just second. Lakshmi is holding the second brief. Yes. That's it. Yes. Three cases have been disposed of by the common judgment. W75C of 2015, the legal case. I'm taking to Ashik next page, page 13, what is the case of the applicant in the original application. All these cases are taken up together, para 2. The applicant are all firemen, and the grievance is that even though they are qualified in the pre-promotional test conducted in the year 2007, yet instead of sending them for training for the post of assistant station officer, Respond number 2, Director General Fire Service, Home Guard and Civil Defense, has directed Respond number 3 to conduct a fresh promotional practical test by letter dated 26/2/2015. This was the subject matter of challenge. Then we also kindly come to paragraph page 30, paragraph 10. That starts with as it appears. The PMR rule 660 has been quoted in the previous paragraph. Then that starts with page 40, as it appears. Let's get it. Top.
Yes.
As it appears, the said rule does not prescribe any time limit with regard to the validity of the result of the pre-promotional test. Relying on the judgment of this tribunal, in number 5.6C of 2012, the Honorable Government Advocate has taken this stand that the validity of the select list for direct recruitment of the promotion shall be 1 year, and such finding of the objection operator adjudicator. Counsel for the applicant objected to such argument, stating that the principle of adjudicator will not apply to the present case, as the issue A number 5.6 of 2012 is completely different. And then we also kindly come to the finding of the tribunal, that is at page 45. Page 45. Second paragraph. And reading onwards. Second paragraph. Regarding the relying upon the judgment referred to above, the observation made in paragraph 9 of the judgment.
Sir, page 45.
Page 45. Page 45.
That starts as thus conspectus.
Thus, yes, thus comes. And the judgment referred to above, the observation made in paragraph 9 of the judgment in A number 5.6 of 2013 cannot be construed to be the ratio decidenty of the judgment, which has any binding effect. No direction has been issued which is required to be complied by the respondent authority. It is an expression of opinion only without being any adjudication, as there have been no issue as to the validity of the select list. The stand of the respondent that issue had already been adjudicated, therefore is not acceptable. The respondent in the counter in roll number 5.6 of 2012 have averred that the merit list is not confined to 3 years. In view of such admission, there cannot be an issue on this point. Issue arises when a material proposition of fact or law is affirmed by one party and denied by the other party. The grievance of the applicant in roll number 5.6 of 2013 is to note down the qualifying marks, and for that prayer was not give effect to the said select list. When arbitrarily 660 of the PMR, which do not provide any time limit, the select list which has been prepared by the Annexure 2 is to be treated as a valid and remain in force till it is adjusted as has been done in the general police. When government advocate has challenged the maintainability on the ground that once the applicant have taken part in the PPT and have become unsuccessful, they cannot turn around and say that their select list should be kept invalid till it is adjusted. In support of such argument, he relied upon a decision reported in so and so, so and so, so and so. There is no dispute with regard to the principle of law laid down in these cases. But factually, those decisions are not applicable to the present case, as Rule 660 of PNR do not prescribe any time limit for the validity of the select list. And as per the practice, it is kept valid till adjusted. And the same practice is being followed in the general police. So it is not a case where the applicant appeared the PPT being fully aware of its validity, that the validity of the select list is limited to 3 years. In view of the foregoing analysis, we conclude that the present law is not hit under the principle of res judicata, as the judgment in law number 5.6 of 2012 in paragraph 9 has no binding effect and can be treated as a ratio decidedly in the judgment, and consequently, as Rule 660 of the PMR do not prescribe any time limit, the select list by the Annexure 2 shall be kept valid till it is adjusted. Accordingly, the is allowed, the order dated by the Annexure 11 of Respondent 2 being not maintainable is quashed, and consequently, Respondent authority are directed to act upon the said select list to consider. This judgment was challenged by in WPC number 135/6 of 2015, that is at Annexure 10, the judgment at page 44 of the brief. And in that application, we are not made parties. The judgment has already been passed by the tribunal. That judgment has been implemented by the state government. We have been allowed to undergo the training. We already completed the course of training, and we have already given effect to that order of the tribunal. We also look page 44. The relevant portion is at page 47. The judgment starts. What is the subject matter of the writ application also? Let's look to that. Paragraph 2. The writ petition is under Article 226, page 47. The writ petition is under Article 226 and 227 of the Constitution of India, wherein the order passed by the tribunal in roll number 625C of 2012, dated 19/12/2014, and the order dated 24/6/2015, passed in roll number 751C of 2015, are under challenge, whereby and whereunder the tribunal, while disposing the original application by allowing the same, has quashed the order dated 26/2/2015, that is the advertisement, and giving declaration that 660 police manual rules do not prescribe any time limit, hence the select list under Annexure 2 shall be kept valid till it is exhausted. Then, if you also come to the ultimate conclusion, para 8, 9. I'm reading the para. We have gone to the order passed by the tribunal and found that the tribunal has come to a conclusion that list will be valid till it is adjusted, and this finding has been given on the basis of the fact that Rule 660A of the Police Manual Rule does not contain any provision or any stipulation regarding the period of validity of the select list. And the upsets thereof, the list will be said to be valid till the name in the list finally will adjusted. But according to our considered view, this finding cannot be said to be sustainable in eye of law for the following reasons. 1. If a candidate would fall in pre-promotional test at the first instance, they will be deprived till the list would be adjusted. There might be a position that in the meanwhile, he may be superannuated from the service. Hence, that will be prejudicial to the interest of such employee, as such would not be said to be proper process to hold a candidate the considered view to be considered once he failed in the selection process. 2. In the meanwhile, new candidates at the time of conducting the pre-promotional test would not have become eligible to be considered. But the meanwhile, they became eligible. Even after becoming eligible, they will be deprived from consideration of their candidature to participate in the pre-promotional test, since it will not be conducted till the entire list will be adjusted. 3. If this process would be said to be correct, the suitable candidate who has not been allowed to participate due to eligibility condition or any other reason, the best amongst would not be selected. In that way, the matter it will be said to be contrary to the principle to search out most suitable person amongst all by selecting the candidate by choosing it from the large number of employee working. Only on the basis of the reasons are of the considered view that finding given by the traveller regarding the validity of the list till it finally exists is not proper, hence the same is hereby set aside. With all respect to our, we will find that the traveller was proceeded on the basis of PMR 650.
Yes.
And
660.
660, I'm sorry. 660, which I can place before also. But the thing that was said, while it was held that traveller was committed wrong and not sustainable, nothing was said about that PMR 660. And more important is, what was the prayer before the traveller? The prayer before the traveller for crossing of that the notification which was made by the director for the pre-promotional test. That was the subject matter. That was not their case that the so-called select list have never been challenged. The contention raised by the intervener that order makes no interference in view of the order passed by this court in WPC number 16027 of 2015, where the similar order has been said to be proper by the division bench of this court in its order dated 21/9/2015. We have gone through the order passed by this court in WPC number 16027 of 2015, disposed of on 21/9/2015, where the Long Council representing the petitioner has confined his prayer only on the selection of 18% when the vacancies occurred in the subsequent year. And a coordinate bench of this court, after taking into consideration the prayer which has been confined, has declined to interfere with the order passed by the traveller. That's very memorable.
Because they are not.
So far, those 18% are concerned because they are not made parties. Therefore, the this honorable division bench of this honorable court held that such the writ application is bound to be dismissed because the person, those who have already got promotion, they have not been made parties. Even the promotion has been made after expiry of 3 years. And that is like, so for the present petitioner are concerned, the stance of the same thing because they have also got promotion and they have completed their training after, just like those 18%, those who have got that benefits. And that has been accepted by the division bench, but that only distinguish it because that is only confined to those 18 persons. It is said out that the issue which has been raised by this petitioner has not been adjudicated by this court. As such, the argument raised by the counsel for the intervener regarding the issue having been decided in WPC number so is rejected. Then we also kindly come to next page, paragraph 11. Page 57, page 57.
I have seen also state council arguing our case.
Yes. Okay. My friend, I'm thankful to also. Also move to paragraph 10 because the state council at that point of time argued in our favor because that was the case throughout. Paragraph 10. Page 56. Sorry, page 56. One council for the intervener as also one council for the state have submitted that there is still vacancy. Since according to them, the selection process has started in 2007, in which 543 candidates have appeared, amongst whom 310 have been found to be suitable, having been figured in the select list. The government has granted promotion as assistant station officer to 175 out of 310 selected candidates. Hence, still the vacancy are available. As such, direction may be given to fill up those vacancies from the select list already prepared by virtue of the selection process initiated in the year 2007. This is the argument advanced by the state. Yes. Then we also kindly come to paragraph 11. Page 57. We, after going through the order passed by the tribunal, have found that tribunal has given no finding with respect to the legality and propriety of the instruction dated 30/2007. I am sure that the tribunal was held that section 12, PMR 12, because that instruction was without the approval of the state government in terms of PMR 12, section 12 of the Police Act. According to us, and in view of the admitted position that there is no recruitment going regarding the field Hence, in the absence of statutory rule, the authority has got power to formulate the guideline by virtue of the executive instruction. The same has been done by the competent authority of the fire services of the state of Orissa by issuing the order dated 13/8/2007, providing the provision and process of selection as assistant selection officer. I pause for a moment, I'm showing you that order dated 13/8/2007 issued by the IG of police without the approval in terms of section 12 of the Police Act. I show that. So therefore, that cannot be said to be a rule.
So we are not expressing any.
Yes. We have also taken into consideration the legality and propriety of the promotion having been granted. Taking into consideration clause 5 of the letter dated 13/8/2007, the selection process since been initiated in the year 2007. The validity of the select list prepared on the basis of the said selection process will be valid for 3 years. That is up to the year 2010. We are making this observation on the basis of the fact the validity of the condition number 5 of the letter dated 13/8/2007 has not been questioned. However, we have already expressed our view that even the select list cannot be said to valid for a period of 3 years or till the framing of the cadre rule, whichever is earlier. But since the government has given effect to the letter dated 2007 and the employees have already been granted permission in pursuant to the same, hence we are not expressing our view regarding the promotion already granted even for 3 years. Now confined to 3 years, as has been decided under condition number 5 dated 13/8/2007. But we look at that 13/8/2007. That is up to 20.
Already been done.
Orissa Police Act of the this is the letter which this honorable court by the division bench of this honorable court, page 20 minutes. This is a letter from Orissa State Fire Service by the IG of police, I think, addressed to, yes, the address to the state government.
The court has directed state government would not grant any promotion from the select list prepared on the.
That question is there.
First, they said we will not comment on these promotions because it has already been done.
Right, sir.
And then do not make more promotion.
The state government would not get the promotion from the select list prepared on the basis of the selection conducted in 2007 for the reason stated here in above. So far as we are the person, we stand the same footing like that 18%, those who have already got promotion, and 107% who have already got promotion from 2 years, and that has not been taken into consideration. We have not been parties also in the writ application. And this honorable court referred to later dated 13/2007 according to the dangerous. Yes, sir. Which has been relied upon by the division bench, by the judgment sought to be reviewed. We also look to the Police Act. What is the provision? Section 12. Picture the Act. Listen. Sir. Right?
मोटा weight. It's general.
I think access book is there. No, it's 595. 595 of the HC book. 595. Maybe.
What is the police rules?
Police rule is 6 PMR. That is there. That is that 5. Yes, sir. 595 is the Police Act. Section 12. Because pursuant to this Police Act, this PMR has also been framed. First, you also kindly look to section 12 so that I can take a receipt to the PMR.
Yes.
Power of Inspector General to make rules. The Inspector General of Police may from time to time, subject to the approval of the state government, frame such order and rules as he shall deem expedient relating to the organization, classification, and distribution of the police force, the places at which the members of the force shall reside, and the particular services to be performed by them, their inspection, description of arms, and also the collecting and communicating with them intelligence information and all such orders rules relating to police process as the Inspector General from time to time expedient and preventing abuse of neglect and duty of rendering suspects efficient in the discharge of duty. What I am giving emphasis here, the Inspector General of Police may from time to time subject to the approval of the state government. Subject to the approval of the state government, that is the criteria, that is the requirement under section 12. Now we also come to the PMR. PMR, your assist book 342 is that 660.
What is the meaning of this section 12? It doesn't give any power to the Inspector General of Police. Power is written by the state government. What is the meaning of this section?
It means he may suggest,
but subject to the approval of the state.
This is a very unknown thing in the legislative process. Because the dustman is not important to us. What is the outcome and who is the authority?
Right.
Authority is the state.
The authority is the state. Right, you're absolutely correct. Absolutely correct. And if you also look to page 20, which has been related by the image,
yes.
Page 20 of the one page 20, then I'll take also to 660.
Turning page 20 of this
application.
There is the letter dated 13/8.
Yes. The last line you also see. The result of the pre-promotional test boards have remained valid for a period of 3 years or till the remaining of the rule by the government, whichever is earlier. This is they themselves have also said this is not binding. The Director General himself has clarified you can give appointment in the terms of 660 because 660 does not say anything. 660 is with the approval of the government. Also, this is by the government. So now at this juncture also look to 660.
All right.
If you also look to page 342. Thank you, sir. 342 page. First, kindly see 660.
Mr.
I have understood that because there is no rule, 660 has not been referred to, since there is no rule, this executive instruction by the IG of police, that which was just read, that will now govern the field.
Or since you have already done it, we are not expressing a view. But henceforth, it should not be done. So have they approved it?
Accepted that in at least in the mountain this, but they continued to 3 years only.
The government at that time supported it.
Government supported it. Government has again looked to the picture. In fact, the IG of police has also clarified that because there is 660 is silent about that, you must give a appointment after even expiring years.
Come to prayer number 1. Come to writ petitions prayer number 1. That's right.
Recall the judgment. Recall the judgment dated 6/7/2017 passed by this honorable court in WPC number 13566 of 2018 and direct the opposite party, particular opposite party 1 to 5, and to allow the petitioner to get the promotional benefit in the post of assistant station officer, as has been done in case of other selectees by passing the order of promotion on 21/10/2010 on annexure 6.
Just explain it. What do you want by this?
We want the judgment passed by this honorable court where they confined it to only validity of the selectees to 3 years and no promotion will begin. Henceforward, as my Lord has pointed out, the operative personnel, no further promotion will be given on the basis of that selectees.
Yes.
That we have agreed by that should be recalled and direction should be made to the opposite parties to give effect to their promotion. So far as we are concerned, as have been done in case of those
of 2010.
That because we have got promotion in 2010, but we have not been allowed to work after even completion of training.
That is, explain that what you want actually. You are getting because there is a 2017 writ petition. They say they're confirmed.
They're confirmed
because up to 3 years this list was valid. In your case, you did not come within the category of 3 years.
You didn't come within the category.
Yes,
As if the judgment of the divisional bench is accepted. But so for the 18% and other person, those who have got promotion after 3 years, we also we stand in same footing.
That is what I'm telling you.
Right. That is, I leave it to your lordship because in fact they have got promotion on the basis of the selectees, they have undergone the training, they have already completed the training, the result have been published. Only the impulsive seniority have been fixed. But in fact, they have not worked till today in the post of the promotional post. That is for your lordship because they are waiting for so many years that it is for your lordship to take it. And 660 is the only provision with regard to the promotion. And that requires the selectees have been prepared in accordance to 660. There is no dispute over that. And training has already undergone by the petitioner. There is no dispute over that. This is a summary.
What about those Supreme Court decisions which says that when there is no rule regarding the life of the panel, in the usual course, it will be only restricted to 1 year. And what will happen to those children? There is a case from Bihar, there is a case from Jammu and Kashmir, there is one case from Rajasthan. So it is very consistent.
This is a peculiar case because
you are arguing that the rule doesn't prescribe anything.
The rule doesn't prescribe any period of validity of the period.
No, nothing.
Nothing. It's accepted that the validity of the period of 3 years. They are accepted throughout. That selectees they are accepted.
Last line of the guideline says 313 letter. In order to fill up the vacancy, ensuing vacancy and anticipated vacancy by the end of
So this is my entire
even the vacancy position, madam.
That confusion about this thing. You may have the vacancies. You can also fill up the vacancies. The question is that whether that the old panel should continue or not. That is that's what. This point is always
yes. I'll assist him. To assist your lordships on the two points. That what is working in the mind, what was working in the mind, maybe now led by them, that this is a final select list, cannot leave for long. This is not a final select list. Minors, in our department, we appear in departmental examinations. Once we are qualified, our name remains as our seniority. Do not change. Whether I secure 50, 60 or 30, 30 is failed. 50 is pass. 60 is also pass. But after passing again, our seniority will remain as it.
The learned counsel perhaps was taking a point, and that is very valid. That suppose the selection has been made.
Yes, if you select
promotional post, that is the thing. These are all promotional posts.
Yes.
We are not dealing with any direct recruitment.
Yes,
promotional post, and there is a selection process has been done. The basis is what? Basis is the availability of the vacancy.
May I assist you, Lord?
Yes.
These constables or the firemen, they appear in a qualifying test. Even if they are qualified, they don't get promotion, do not go to the select list. This is a qualifying list. The problem is, everybody says it's a select list. It's not a select list. It's a qualifying list. Prepare.
According to in the zone of consideration because of
yes, they come in the zone of consideration.
Yes, qualifying test.
Once qualified, they can be considered.
Yes.
So then what happens?
That perhaps you are pointing that someone is once qualified through the
cannot be asked. I believe that is qualified. So that's what I'm driving at.
Yes.
These persons are qualified persons. We are all qualified persons. Some of us have been trained and completed the training successfully.
Yes.
That's another thing. My lords, once you are qualified, then as per vacancy, they are called to Central Selection Board. Initially, as he read out, my lords, 20%, sometime 18%, 117% sometime. That body prepares a merit list, select list. And from out of that, he sends for training.
So yes, I want to clarify one thing. Whether the merit list is prepared against the vacancies or the merit list prepared for in perpetuity.
This case was prepared only qualifying list. This is only a qualified list.
Okay.
They need not bother for that. So once qualified, I'm waiting for the Central Selection Board to call me, examine my CCA, and at that time also put me before a medical board. For example, it may work in the mind of the court that a man qualified in 2007 and 2017, he is still to be called to be officer. Yes, a medical board is there, a selection board is there. He looked to his CCA. So while passing that order, the earlier division went mandates, everybody going on telling select list, and therefore apparently it was said the select list cannot live for a long. The question is, we are all qualified. 2007, we appeared examination, and anxiety has been, I may be excused, anxiety has been expressed in that judgment that those who did not qualify that time, they will wait for anxiety was expressed for those who have failed. Anxiety was not expressed for those who have passed or went to training and qualified. And even if they are not before the court, that's what my submission is. Had opportunity been given to me, I would have explained to the division bench then, and also today I am trying to explain. This is some of the constables, those who are eligible, means 7-year service, they become eligible. They appear in the test and become qualified. Then, as and when vacancy comes, they are considered by the Central Selection Board and a medical board. Then a merit list is prepared. Such a merit list, your lordship can always ask, as has been said by the Supreme Court some cases, that in absence of rule, it should go for 1 year. So this is not our case. We all are qualified, trained. But without hearing us, had opportunity been given, we would have only said, it's not a select list, it's a qualified list. Because
but can you tell us that according to the list, those who have been appointed on the basis of the within 3 years cap, since they are within the 3 years cap, they are appointed. And you are admitting that we are not within 3 years cap.
After 3 years, 175% appointed.
Oh, that is why
18.
The question
is, this document
being prejudicially affected. How you are bringing in this context?
That's what I am trying to drive at. Your lordship,
merely because you could have advanced on the alternative submission doesn't give the court an opportunity to just reverse the judgment.
No, I
judgment.
Possibly.
You have to show that your substantive right.
If you actually look to the judgment of the tribunal, which are the subject matter challenge for the division bench. In fact, the tribunal say to give appointment out of that list is exhausted. On the basis of that judgment of the tribunal, in fact, the promotion order was issued and we have allowed to go on under training. We completed the training. That is our right, which is accrued on the basis of the judgment of the tribunal.
Mr. Also, I understand that.
Yes, sir.
But your prayer, that is why I'm pointing at the relief number 1. You say that this judgment of 2017 has to be recalled.
Yes.
What is your status to ask this to the court? Because you are not expressing any grievance against these persons, those who are in the 3 years cap and appointed.
No, absolutely not.
So then you are not prejudicially affected by that judgment. We have also accrued such a certain right.
Well, just for a moment.
Yes.
So also look to that page 29.
So that is
what, in fact, that Judicial was rightly said. Also look to the page 29, the last line.
Yes.
We are not expressing our views regarding the promotion already granted within the period of 3 years.
Yes.
As has been decided on condition number 5. So far as we are concerned, we are going for 3 years. There is no dispute over that.
Right.
Person, those who have also appointed beyond 3 years, 18%, 90%, those have also got the appointment after 3 years.
But they are also covered by the judgment, 8%.
Yes, yes. That's right. Yes, also. And the main thing is, I
think that your entire argument was to be treated like that 8%.
Sir.
Right? So how can you attack that judgment?
So only that portion.
Yes, that is only that person. Yes, so I would like to say that is only that person. That person only. Not years.
They're within 3 years.
Within 3 years. That confined to 3. Yes. Actually, and another thing you also pointed out, that is also very pertinent question, that has been answered by the division bench itself at page 28. So far the vacancy position is concerned. Para 10 I have read, but I have taken the issue to para 11. Para 10 the second, of the person. Yes. So look to page 28. Page 28. Well, I am not interfering on this. The argument of the council is not acceptable, and state council's argument was not acceptable to this court for the reasons. Admittedly, the selection process started in the year 2007. Out of 543 candidates appeared in the process, 310 have been selected. List has been prepared in the year 2007 itself. We are now in 2017, and still 135 candidates are to be promoted out of 310 selected candidates, while the vacancies 161 are in 2007.
Vacancies were there. We were there.
So we are coming within this select list against those vacancies. That's all, man. I will not disturb you.
All right. I will complete, Mr. Mohan.
No, I will complete. I will only beg your lordships.
Sir, not only that 18%, if your lordship will look to page 2 of my date chart.
The chronology of events.
Chronological date of events. Only one thing, just yes, sir. Because factual aspect must be very clear. Serial number 6.
107.
Yes, sir. We also see the select list of prepared on 16/10/2007. But this was 21/10/2010. After 3 years, 107 number of candidates were given permission to be placed.
This 107 appointments and promotion doesn't have anything to do with that judgment.
Judgment, if the judge.
After this judgment, some more were appointed.
No. We are all waiting for that.
We are all waiting for
You are saying that 7 to 8%.
Persons were appointed after expiry of 3 years of that list.
No, before the judgment or after?
3 years of before the judgment. March before the judgment.
So that was 21/10/2020. After that, this calculation has been made.
Yes, sir. 21/10/2010.
Yes.
So I have 107 and 18. That's all. No, I'm not.
That is what you call. I wanted to say about 130%. After that, they got. So actually, that date has no problem. That 3 years, apparently somebody clerically or somebody written, it was every day our clerks in the departments. They appear departmental examination, wait for a promotion to senior assistant or to the section officer. So that is nothing with this qualification. Asking that this list of qualified persons should go after 3 years. It's a redundant. It was a non-application mind, apparently.
You are saying that once they have passed, it will continue when you are promoted.
Occasion will arise. Actually, the rigorous question is there. The Central Selection Board examines the whole service record and that actually, if the confusion rose because everybody carried that this list is select list. It's a not select, it's a qualifying person's list.
Exactly.
My lord,
always because you have stated one thing that is very important. This is the Central Recruitment Board or the...
They have to ultimately examine.
They will ultimately you examine and then you have to go through the medical test. Unless your fitness is...
weight and balances are there, my lords. So, had we been there before your lordship in the other division bench, we would have said this. And things would have... And anxiety has been expressed for those who have failed with us. We passed, we will be nowhere. And I face examination for the young persons or those who have failed. Some misplaced sympathy, my lords, with great humility I am asking, my lords, unless you have come to the rescue of these, their government servants, trained by them, qualified by them, and still will have to go for another test, or the young people with a new course will not be in a position to match with them also.
Total
Well,
This qualification is not enough. If there is suppose there are four parts of curriculum. This is the first part we are concerned now that they qualified in the first part.
They're saying we passed, now they're prescribed physical test. They're saying once we have passed that, no physical test necessary. What difference?
Means what difference? Policy. I know 59. Oh, all right. Yes, we will complete. Can I complete today? Because we have a fixed matter in the chamber at 4 p.m. So we have to continue. We'll continue tomorrow.
Tomorrow, I'm not there. I am not problem. Tomorrow at 12 o'clock, I have some side and go. Then I should fix it to 16.
All right.
16th.
Tomorrow will also take the first matter. I will take another half.
No. 16.
I don't think they have completed.
But keep it to 16th.
16 2 p.m.
Yes.
I think 16 2 p.m. already one matter has been. It's all
Interim order to.
just from this case was
Only interim order to continue.
this WPC number the mail is very order will be indicated. WPC number 19875 of 2019. Vinodar Vihara versus we have heard Mr. B. Rautwal, our senior counsel. Who is assisting you today?
My lords.
Shakti Shekhar, and Mr. M. Mohanty, the senior counsel, tested by Mr. Shakti Shekhar for the petition. Huh? MR Mohanty. I see what was the solution. In part, and for continuation here, we come out in 16 2022. P. Mudali, additional government executives for the state opposition parties. State opposition for number 1 to 5. All right, item number 59. Now we call other matters. We'll give the time. Yes.
No, 39. We'll also have this matter. In fact, we have closed. So far, Mr. Kuntia has to, we're also directed to take instruction. So can you also fix it also 16 or 17 any date? Because today there is no time.
Kuntia, do you have read this, that matter? Adopting the scheme.
Yes, madam. Fix any date next week.
Are you having your?
Yes, I have got that instruction, so they are not.
Again, not agreeable.
Thank you.
Mr. 17th, what is the position of 17th? 17th.
Item 30 also same prayer lordship. Item 30.
30. 17th.
That one.
Yes.
It reminds me to say that interim order is there. Item 20.
It's already mentioned.
Interim order continue.
Item 31, my lord. Next week, 17. Item 39, 18.
39.
Maybe 18.
Okay.
Item 31, my lord. Next week, date, my lord.
Which one?
Item 31, my lord. Significant order of state, my lord.
Okay. For the respondent.
31. Appellant is the state.
Okay, 31.
Any date, there is no offense.
No offense, my lord. Because matter is state. Only simple matter, only mutation matter, my lord.
All right, we take up the matter on 28th of August.
Lordship 54 item.
Not possible, board is not permitting it. Just see the, how many matters you have to leave. 28th of August. Leave the 31, yes.
Lordship item 54.
And the 35% also there in the circular, where the annexure E, page 141. Same annexure E, page, that is counter to rejoinder, page 138. My lord, I was asking, where is the 35%? The 35% is very clearly there. That was a specific issue was made and that was answered in paragraph 6. And your lordship kindly come page 138.
No, I was asking either by the rule.
35% circular, the circular what happened, annexure A will have that Hindi and that English version.
You are referring to page?
Page will annexure E, page 138, counter to rejoinder, page 38. Running page is 138.
You are dated 31/3/2000.
138, 31/3/2012.
Yes.
So last come to page 148. Clause 7, II. VII. Yes, you got it. VII. Page 1, page 41, that is running page 141. The marks for interview shall be awarded by the interview committee constituted by the chairman and managing director or executive director in the absence of chairman and managing director. Candidates have to secure minimum 35 per month for interview. And the annexure B will add, here also the
reading the marks. This is in page 41, so there is no such thing. Page 141.
Yes, 141.
Now, what is that? In which para?
That is common guidelines for promotion from JMS from 2 to 3 and 2. And Roman 1,
Yes.
Roman 7.
Maybe you are not on the same page. Just let us.
This is and the copy also there. This is
the copy and mark you did from page.
He is referring to internal paging, page 41.
You are referring to the writ petition.
Yes. Writ petition related, that is not annexure. Counter we have annexed, that is annexure A and annexure E, the same. This is annexure E. There in the annexure A, that page was omitted, only 31(3) that circular was given. My lord was asking specifically that where is that 35%? This is the 35%, this is the circular.
Circular is prepared on the basis of the resolution. So resolution, that portion you point out.
Yes, that is the circular. And accordingly,
please point it out from a resolution because your circular is based on the resolution. So
getting the circular. Where is the answer? Open in the writ petition. He says 141 page. There is the circular, it's all right.
Circular number 444.
Yes, yes. This is the circular.
And thereafter,
just wait. Don't move so fast.
Page 141. Normal seniority channel.
138, circular page 138, starts 138. And
annexure E starts at 38. 38, yes.
38 and 40, this is there.
41.
That is the problem. Your presentation and presentation in the record are completely different.
Yes, 41 where?
Roman 7 minute.
The marks for interview shall be awarded.
Common guidelines promotion to 1, 2, 3, 4 minutes 7.
This is.
Lordship got it. The marks for interview shall be awarded by the
page 144.
144 million.
That is the difficulty that we are searching in the 141.
But the page mark, parallel page mark is included.
Okay.
If the lordship passes, I will parallel page mark. My associate will do it so that will be no confusion.
Page 246 of the PDF page number.
No, I found that. But that is supposed to be based on something that I was asking since yesterday.
See, Ratna was asking yesterday also, but exactly same, where is that?
I was saying.
That was the annexure that page number.
You have said annexure E is based on annexure D. So where is it in annexure D?
Annexure, that is annexure E, annexure E.
I have understood annexure E, but in the requirements in that affidavit, they have
Annexure that circular 31 to 35.
annexure D.
Okay, that is there. Clearly it is provided. Okay.
Here also I will point out that.
No, this already you got it.
And Milad,
44.
Paragraph 6, Milad, you are also seeing the judgment. Specifically, this point was dealt with. After Milad, discussing everything, at paragraph 6 of the judgment, the court has made an issue and that was answered relying on this. And thereafter, annexure B on the basis of annexure B, he has appealed, knowing about this, and thereafter, he has not passed.
So you bring all the decisions regarding this estoppel by conduct.
Yes.
That's all.
That is only. This is unless this is there, this 35% is there. Your lordship said that he has not and he was paid. And he has not challenged that. That is 2016. And now, after successful, he cannot trace the estoppel. And
this law is settled. Don't argue on that. Yes, Mr. Counsel for the petitioner.
He has to be unmuted.
Your Lordship.
Yes.
Your Lordship, the case of the respondent says that this requirement of 35% marks is there, is provided there in circular dated 31/3/2012. This circular they have averred in their counter to rejoinder that it is based on board resolution dated 17/3/2012, which is annexure D. Now, Your Lordship, this requirement of providing 35% marks is not there in the board resolution. So, unless merely by way of a circular.
You look at page 33. Annexure D, page 33.
Your Lordship. 33 I have seen, Your Lordship. Page 33 are the requirements, but page 33 the requirement of interview is not there.
Right side? Oh no, that is MSD. Wait, I've seen it somewhere. Sorry, page 32. Page 32, bottom, right side, bottom.
Yes.
It is weightage given. Provision for interview is there. The
35.
The provision for interview is there, but provision for disqualifying a candidate in case of not getting 33% marks is not there. Here the
show from the circular in annexure E of the writ petition.
Your Lordship.
Because they are saying that circular is based on this. So that is why I was looking at where it stated that.
So your final argument is that since this kind of resolution was never taken by the board of directors, this circular is a mere executive instruction without proper approval of the competent authority.
Yes, Your Lordship. And my further argument.
But there is another question, right or wrong.
Your Lordship.
This circular was in existence and knowing participated there.
Your Lordship.
That can be taken against you as an estoppel by conduct.
Your Lordship, estoppel by conduct is definitely a principle, but Your Lordship, there is a recent judgment by Honorable Supreme Court 2022 Krishna Rai versus Banaras Hindu University, where Honorable Supreme Court has laid down that this estoppel by conduct principle does not apply.
You have a copy of the judgment because I missed the first name of the citation.
Please repeat the name again.
Your Lordship, Your Lordship, Your Lordship. This is Krishna Rai versus Banaras Hindu University 2002 judgment, Your Lordship.
Krishna or Krishna?
Krishna Rai.
Reshma.
Krishna, Lord Krishna, Your Lordship.
Okay.
Your Lordship, I will say request my associate to present before the court to hand over a copy of the judgment during the course of the day, Your Lordship.
You said this is which date? Judgment of which date you have it? The date?
Your Lordship, I will hand over a copy of the judgment.
I don't have the copy, Your Lordship. I don't have the copy, Your Lordship. I will submit it.
I will print it out and supply, Your Lordship.
All right, just supply the copy. Okay, we'll look into that judgment.
And further, Your Lordship,
Yesterday I mentioned about 53 persons above him.
Yes. More marks, but because they did not get not.
All this we had discussed during the judgment. 3 years we had, all the 3 years.
Same.
Persons above him, about in case 63 and another case 33, another 37 persons above him. They were also not qualified.
All this.
That is judgment.
All right, you got your points.
Your Lordship, my further point in this regard is that even if that was there in the board, even if it had been provided by the board of the bank, even if this requirement was there in the resolution of the board, it still would be a violation of the government guidelines which the government of India has put in place, specifically directing that what we are concerned about, that different banks are adopting different methods of promotion. So therefore, these being public sector banks, we want a uniform process and standards of promotion in all the banks.
I think these are the very good grounds. Before your participating interview, you have challenged that policy of the bank. Now you have participated, even there is a justice, look into the 2019 Justice Chandrachud judgment says, even you cannot also question the constitutionality of this kind of policy after participating in that. This is an extreme judgment is there.
Your Lordship, in this matter, I will submit, there is a recent judgment that I will submit taking note of all previous judgments of Honorable Supreme Court. A hard copy will be submitted before Your Lordship, where it has been laid down that when it
we are keeping it on 16th of August. Please, your compilation file on that day, because they have a right to reply to your proposition of law.
And also, we are also in each presence, the argument was made, and judgments were the para 5. All the judgments were dealt with. I have also filed that is here.
Yes. List on 16/8. 2023, the request of Mr. Sajjan, as his name is there in the last order for the petition or the appearing to the appellant. So on that day, the appellant shall file the citation that we relied in support of their contention. So we have heard today Mr. C. Anand Rao, learned counsel, who has appeared for the respondent bank in full stop. We will not entertain any oral submission on that day. Only we will take on record the citation that will be filed by the counsel for the appellant. You keep it there, the citation.
Your Lordship, if Your Lordship wants to, this is civil appeal number 47457.
16 June 2022.
4578 of 2022.
All right. You file your citations that you say that you filed all the citations filed. which he supports you or which will also not support you. Because he has a responsibility.
Meanwhile, he was compulsorily retired because of the disciplinary proceeding. SUBHASIS, that is Annexure J. With
That matter is also pending before this honorable.
sexual harassment is
The point that has been has fallen before us, we will only decide that. Others we only take note of because we do not know. Because it has been challenged already.
Yes, writ application is pending.
Yes.
That break, Millard, I will point out all these things.
But I will not permit you time. So whatever we want to point out, hand over a very short note within a 1 page.
Yes, Millard.
Issue is very simple.
Already there, that site has
an issue that whether the 35% by the board or not, that is one issue. Whether that is against the policy of the government of India because you are a public undertaking, their guidelines or their various rules have any impact on your rules and should have the impact. This is the two aspects is raising and all the judgment will be given. One is on the question of the public policy and transparency. Right. All right.
Only thing I have already submitted.
All right, the learned council, we have no time. We have a matter fixed in our chamber.
Extremely sorry. Apologies, Your Lordship.
All right.